Good morning, everyone, and welcome to the SFA Employment Law Seminar. The COVID pandemic has drastically changed the way we live and work, and it has never been more vital to explore the changes and developments that small business owners are facing from HR and employment law perspective. And in our webinar this morning, we will focus on HR and occupational health and safety considerations. We're looking at employment permits, probation, as well as upcoming HR trends and legislation. Just to walk you through our program, we're going to start with Lorraine Parks, who is IBEC Knowledge Center Senior Executive, and Ruth Heenan. She works in the Employer Relations team in IBEC, and the two of them are going to look at the very important question of OHS, occupational health and safety considerations in the context of COVID-19. We're going to give you a 20-minute tea and coffee break, and you can answer your emails between 10:25 and 10:45. And after the break, we have Ananta Kaur. She's IBEC Employer Relations Executive, and she'll be talking about employment permits and visas. This will be then followed by how to manage probation. Fiona Mulligan, she is on the SFA team in charge of Childhood Services Ireland, and she will talk you through the various aspects of managing the probationary periods. And last but not least, our very own Emma Crowley, and she's going to talk to you about the new HR and employment legislations that are coming down the tracks. Just to say that at the end of each session, you will have the opportunity to ask questions using the chat box on your top right-hand corner of your screen. And we're going to try and answer your questions live during this seminar this morning. If you're unable to answer them because we're running out of time, we will take them offline and get back to you in any case afterwards. We'll be recording the session today, and you will receive the recording together with the slides later this afternoon. Before I start, a big thank you to Luke and the IBEC webinar team for facilitating the session this morning. And now, without any further ado, I hand you over to Lorraine and Ruth, one of the really busy members of the IBEC team, because obviously health and safety considerations in a COVID context are keeping them really busy. So welcome to the program.
Well, good morning, everybody. As Sven said, my name is Lorraine Parks and I work in IBEC's Knowledge Centre. So this morning, I'm just going to take a look at some of the major COVID-related legislative developments that we've witnessed over the past 12 months in particular, touch on the frequently asked questions that have certainly that we've been receiving over the last year and that are very topical at the moment around the people management space. And then finally, I'm going to just draw your attention to some very interesting recent case law that I suppose has emerged on foot of changes and developments that are COVID related. So I might just pop off my camera so that everybody can focus on the slides and we'll go through it, and I'm happy to take questions via Emma at the end. So again, just the main legislative change is always useful to have at the back of your mind, particularly for organisations that perhaps either have gone through significant change in the last year, and I think that's most employers, and those that might have been closed in recent months, particularly since Christmas, and are now looking perhaps with the signals that are coming from government to be in a position to reopen, perhaps from next month or certainly into June. Again, the HR people management frequently asked questions that should resonate with everybody. And as I said, some recent COVID related case law. So turning first then to some of the big ticket COVID-19 legislation and guidance that we've seen over the past 12 months. People will recall that around about last March and April, we saw the introduction of the Health Preservation, Protection and Emergency Measures in the Public Interest Act. And that, of course, was very significant, not least because it introduced the enhanced COVID illness benefit, and it allowed the minister to make regulations to slow the spread of the virus. We then saw SI 296 of 2020, and that was recently extended under SI 512. And that is the regulation that requires a person to wear a face covering in relevant premises, for example, public transport, hair salons, retail outlets, unless they have a reasonable excuse. And my colleague Ruth will build out on that whole piece around, I suppose, the COVID-related health and safety measures, and in particular that piece around face coverings and face masks. We also saw the emergency measures in the Public Interest COVID-19 Act of 2020, and that, again, very significant in that it introduced the wage subsidy scheme, and very significantly for a lot of employers, I think, it suspended the redundancy trigger, but more of that anon. Then we saw the Resilience and Recovery Plan 2020 to 21, and this was the plan for living with COVID-19, which was published by government in September 2020. And then I suppose underpinning all of that, we had the Return to Work Safely Protocol, first published in May 2020, and the Work Safely Protocol, which built out on that and which was published in November of last year. So turning back to the wage subsidy scheme for a moment, you'll be aware that that operated from the 26th of March to the 31st of August of last year. It replaced the employer COVID-19 refund scheme, which was quite short-lived. It was available to those who kept employees on payroll. Revenue, as we know, published names of all of those availing, and over 659,000 employees essentially availed of the scheme since the start, and there were almost 70,000 employers registered. Now we know that, and I think there were ambitions at the time that the wage subsidy scheme might see employers through what was thought to be maybe a surge of the pandemic and all would be sorted by the end of the summer. But of course, it became evident that we were in a position where we'd be living with COVID for a little bit longer. And so we had the employer wage subsidy scheme introduced on the 1st of September of 2020. That scheme focuses mainly on business eligibility, flat rate subsidy, again, revenue publishing names of employers availing. And we know that the most recent data available tells us that 49,000 employers as of mid-April of this year were employed for the scheme, and it will continue to the 30th of June 2021. The pandemic unemployment payment was introduced, as we know, and available to those who lost employment or placed on layoff due to COVID-19. Initially, it was paid at a flat rate of €350. Since the 16th of October, new rates were introduced based on earnings. And significantly, the PUP is currently scheduled to continue until the 30th of June 2021. Similarly, the COVID enhanced illness benefit. So remember, this is the benefit for people who are either required to self-isolate on foot of a HSE instruction or by their doctor, or who've been diagnosed with COVID-19, are entitled to the COVID enhanced illness benefit, $350 per week. And again, similar to the regulation and the timeline for the PUP and for the suspension of the redundancy trigger, again, all of this due to, at the moment, last until the 30th of June 2021. So back to our redundancy trigger. Traditionally, listeners will be aware that the redundancy payments legislation permits someone who's been placed on a period of temporary layoff or a period of short time for 4 consecutive weeks or a total of 6 weeks in a 13-week period to trigger their own entitlement to a redundancy payment. The emergency measures in the public interest legislation has suspended that entitlement on the part of employees. The reason being, of course, that against the backdrop of COVID and an employer's ability to return them to work, there was a real concern that it would cause a tsunami of redundancy payment claims and essentially cause a lot of businesses to potentially go out of business. So as we say, that suspension of the redundancy trigger, again, employers have the comfort of the fact that an employee who is still on layoff or on short time does not have the ability currently to trigger their own redundancy, certainly until the 30th of June 2021. And it remains to be seen what happens after that. Just touching briefly on the return to work safely protocol, I think a lot of listeners are probably very familiar with it already, insofar as many organisations may have been in a position to reopen for a while. Some have remained open, of course, and are very familiar with the measures introduced in the return to work safely protocol. Big focus in it in terms of measures for employers to put in place to ensure a person's safety at work during COVID, the appointment of a lead worker representative, updating business and safety plans, including the business COVID-19 response plan, and how to deal with a suspected case of COVID, of course, intrinsic to all of that. Also, a big endorsement of staying safe at work, employers and employees to familiarise themselves with COVID symptoms, and employers to ensure hygiene measures, social distancing, contact logs and regular cleaning, all of which of course continues apace. A word then on the work safely protocol published in November 2020. So this was a refinement, I suppose, of the earlier version. And what did it do? Well, mainly updated the public health advice in relation to control of outbreaks, selection of hand sanitizer, wearing of masks and ventilation in the workplaces. The Health and Safety Authority, in parallel with publishing the protocol, issued a new set of checklists and templates which employers could use in terms of implementing the protocol, and of course they are still available. Touching then, I suppose, to bring us a little bit more up to date, the Resilience and Recovery Plan 2020 to 2021 was the government's initial plan for living with COVID-19. Published in September 2020, it replaced an earlier roadmap for reopening society and business, and it was the document, I suppose, that set out the 5 levels that correspond to the severity of COVID-19 in a various location. Different levels we knew could be in place in different locations of the country. Level 1 for locations where COVID-19 was the least severe, and then level 5 where it was most severe. And we'll recall that that very much was a feature of the months of October and November of last year. And then, of course, we had the reopening in December of a lot of businesses, cafes, bars that served food. So some, I suppose, green shoots. Unfortunately then, what had been intended as a bit of a reprieve until the 6th of January, we know was kind of called to a halt much sooner because of a surge in the cases. The current plan then is the Resilience and Recovery 2021, the path ahead. So this, listeners will know, was published on the 23rd of February of this year. Full level 5 restrictions were introduced until the 5th of March 2021. Level 5 restrictions then extended to the 5th of April, but with the proviso that from the 12th of April then, certain travel restrictions, outdoor gatherings, construction and schools might be relaxed. And this would be travel within a person's county, of course, the limited outdoor gatherings, a little bit of a return on the construction front. From the 19th of April then, some lifting of restrictions on sports and exercise, and then as the month goes on from next Monday, some change to the numbers who can attend funerals, sports and exercise, and some visitor attractions. But certainly this week, all of the signals from government are that coming into May, they're expecting more easing of restrictions and are looking seriously at the phased reopening of the non-essential retailers and personal services such as hairdressers, religious services, so forth. And so I suppose that is why a lot of employers now are focused on, okay, if we have not been operating over the last number of weeks or months, what do we need to do to prepare for employees returning to the workplace? And so we've devised a sort of a checklist of the key considerations that an employer should be looking at, taking on board, just to I suppose, organise their plans and thoughts for that return. So prepare workforce planning and rosters, prepare reintegration and induction programmes. So to take account of the new safety protocols or new ways of working, as basic as entry and exit protocols in terms of the building, consideration to people working in pods, hygiene stations, a sick bay for somebody who's displaying symptoms or that could be COVID related. Also very important to identify retraining needs in other or new areas of operations. Something that my colleague Ananta will touch on as she speaks later in the morning. Important to validate work permissions and renewals as required. So if it is the case that you have employees who are non-EEA nationals, perhaps they're non-EEA students, or they're people on work permits or on IRP card permission, just do your, I suppose, audit to ensure that all of their permissions are up to date. Also, anticipate potential claims for redundancy. So we know that the pause on employees' entitlement ends at the scheduled date of the 30th of June. It remains to be seen what happens then. Will it be pushed on? Will it be extended again, perhaps with the COVID illness benefit, perhaps with the PUP? But that all of that really is uncertain at the moment, so we can't rely on it. Give some consideration in terms of how you will manage people who leave, who've decided not to come back. Also, if an employee has relocated within or outside of the Irish jurisdiction, how will you deal with that? Employees' refusal to return due to health concerns, and that can be a big one. Not least, and I know we hear this anecdotally where someone believes that, well, do you know, I'm on the pandemic unemployment payment and I'm almost as well off. I think I'll sit tight. You know, you need to think in terms of how you're going to manage that. You know, facilitating people who really have concerns, who have other issues around coming back, but really, I suppose, just anticipating how you will deal with it when it arises is important. Also, very important to schedule training in line with the work safely protocol and the COVID response plan. Back to the nitty-gritty then types of queries that I suppose we've been fielding in recent time is, how do we decide who to return from layoff or short time? Because a lot of organisations may anticipate that while they may have some permission to reopen, it might not be at full capacity for a while. And what are the key considerations there? So we would say, ensure a fair and objective mechanism based on business needs for returning workers back to the workplace. So you might want to be looking at a competence matrix, or it may be as fundamental as we need certain roles back because that's where we're going to get the footfall, or these particular areas of the business are where we will be restarting soonest. And so on a needs basis, perhaps it's those people with those skills. But in any event, very important to communicate the reopening plans with staff. Ensure all staff complete a pre-return to work form, and callback should comply with employment legislation. So just be very mindful of avoiding the pitfalls of opting, for example, to call back younger workers first, because this could be considered a breach on grounds of age under the Employment Equality Acts. Consult with staff who may need or seek adjustments to work hours. So again, you know, certainly this was a feature and a characteristic of operating during COVID, and the public people and employees who might be dependent on public transport may be looking to stagger their start-finish times as public transport becomes a little busier again. If people are looking for adjustments there, do see whether it might be possible to facilitate that. And factor in the possibility of further delays in returning to work if staff have to quarantine having returned from abroad. And I suppose that's particularly a factor if you are an organisation with employees who've perhaps returned to their home in another jurisdiction, and depending on whether they're in what we might call a category 1 or a category 2, so those very high risk countries where the instance of COVID is very high, where there may be a requirement for them to engage in a period of mandatory quarantine when they return. So important, as I say, to bear these things in mind. What are the key considerations then in returning employees to office from remote working? So again, ensure a fair and objective process for managing the return to work. Seek the views of staff to determine the level of flexible working that might be available, and what is the optimum level of hybrid or remote working that the business might be able to support. So again, if these are people who aren't customer facing, they're people who are office workers, they're returning now, and perhaps as other areas of your business return to production or service, you may be faced with employees seeking to work a number of days from home, or maybe even full-time from home. And I suppose important to look at and to consider in advance how you might deal with that if it arises. Other queries then that really are coming in at pace these days is the whole issue of managing annual leave. So in some instances, employees are returning to the workplace with quite an amount of leave built up and accrued, not taken over a long number of months because they've been on short time or layoff and perhaps didn't take leave that they had from last year. So we have that whole piece around companies saying, well, we have a policy whereby usually somebody has to take 2 weeks only in the summer, and really we can't facilitate people taking any more, yet we have people with a large balance of annual leave. Can we depart from our policy? And so it may be the case that you can, it may be the case that you're a little concerned that you won't be properly resourced if you do. And so again, it's just anticipating the queries that might come in and having a game plan in terms of how you might deal with them, or the scope you might have to depart from your usual policy. Addressing rights to travel abroad for non-essential purposes. Now, this is a big one, and it I suppose is an issue that will evolve as the summer rolls on. We know that with the vaccine rollout, we'll have more people vaccinated, but in addition, you will have employees who might flag to you that they're planning to take some holidays and that they're planning to travel to Lanzarote or another foreign clime if they can, to spend their holidays there. And that brings up very large issues in terms of, well, if it is the case that we need them working, we need them on site when they return, how do we tackle this? Now, it's a difficult one insofar as this situation, this landscape will evolve as the summer goes on. But as it currently stands, we know that if somebody travels abroad against public health advice for holiday purposes, when they return, depending on where they've been, they will not be available to come back onto your site, because they'll either have to undergo a period of mandatory hotel quarantine, or they'll have to, if they're coming from what we'd call a category 1 country, restrict their movements and quarantine at home. So big issues there, and one to watch. And again, my colleague Ruth will flesh out this particular issue in a lot more detail. Another thing to flag, of course, is the right to disconnect policy on foot of the code of practice that came into effect on the 1st of April of this year. So this code gives employees the right to disengage from work, to disconnect from mobile devices that are work mobile devices, or they have a right to disengage from frequent and routine communication from their employer outside of their contractual working hours. So again, that's not to say that it can't happen, that occasionally a business mightn't be able to contact someone, or if somebody's on call or on standby, of course, that is permitted. But just be mindful that that code of practice, which came in on the 1st of April, requires employers to introduce a policy, to develop it in association with employees, and to share it so everybody knows where they stand. Then another big ticket item, which I'm sure Emma will be mentioning later on, is this right to request remote working, which we will see introduced again by way of code of practice, and that's expected by Q3 of 2021. So we don't know the shape of that yet, insofar as there's no, I suppose, other than the proposal to introduce it. At the moment, there's a public consultation with the stakeholders, employers, trade unions and other interested bodies looking to put some shape on this. But what we know for certain is that it will come, and that there will be a code that will allow employees to request remote working. What remains to be seen is the grounds on which an employer can decline that request. So more on that, as I say, to come. Managing absence then. COVID, self-isolation or illness, of course, has presented challenges over the last number of months. Now the infection rates are going down, and hopefully with that, the challenges that has presented for employers will diminish accordingly. But again, something just to be mindful of if you're returning to the office, returning to the workplace after a period during which you haven't been operating, that in terms of resourcing, your rosters, just hedging your bets in terms of if it is the case that you have a number of people who are ill or self-isolating, do you have the resources to backfill, I suppose, their occupations while they're absent? Another frequently asked question that's trending very strongly with us is this issue of managing non-compliance with COVID measures. So that can range, you know, I suppose across the board, but one of the big features there is employees not wearing face coverings when they are required to do. And again, Ruth, whose presentation is coming up just after mine, will be building out on that one in a great deal of detail. Just then to draw your attention to some recent COVID-related case law, which I think is quite interesting. And I suppose last autumn and coming into the winter, a lot of employers and a lot of practitioners in the HR and the IR and employment law space were very mindful that we were in such uncharted territory that we were likely to see a spike in COVID-related cases. And we've begun to see some of those WRC cases come to fruition now. And I'm just drawing your attention here to a small number of them. So in this first one, a financial controller versus a hotel, a finance manager whose temporary wage subsidized earnings were topped up to net, not gross pay, took a claim against his employer to say that that constituted an unlawful deduction from his wages. Now, the financial controller also argued that because he would have a tax liability at the end, well, the end of the year, I suppose, notwithstanding the fact that we know that that tax can be repaid to revenue over a 4-year period, he was one of the first out of the traps to take that claim against his employer. But very usefully, the WRC adjudication officer in his findings in the case stated, having reviewed the evidence presented at the hearing, I am satisfied that the reduction in pay effected by the employer respondent was authorised by statute. So in other words, the employer was prevented and precluded under the rules of the scheme from topping up the individual to gross pay, and essentially found that it did not constitute an unlawful deduction. So that was a case that was welcomed by quite a lot of employers who have claims and I suppose employees, claimants waiting in the wings to take similar cases. The second case then was an instance where the Labour Court gave a manufacturer a period of time to restore pay reduced as a result of COVID social distancing measures and a fall in sales revenue. So this particular manufacturer, because of the requirement to minimise the number of general operatives on site at any one time, was forced to introduce an evening shift and even a weekend shift. So on foot of that, it meant that a certain amount of overtime was lost by some of the employees who would have worked quite long hours and then worked weekends as well. In summary, what the Labour Court said was, yes, it was a change in their terms and conditions of employment, that the communication around the issue could have been better, but interestingly, gave the employer a long period of time during which to repay the shortfall in wages, which I think is a decision, again, that'll be welcomed by a lot of employers where they're financially stretched and given the circumstances that they were stuck between a rock and a hard place, insofar as they couldn't provide or allow for everybody to be on site at the same time as they normally would be, complying with those health and safety requirements, and it had this effect in terms of the overtime earnings. So again, a useful decision. Then just finally, to draw your attention to a recent case of an operations coordinator versus a facilities management service provider. So this was an individual who worked for a facilities management organisation. She was based in a university in their accommodation facility, and she had been living with someone who had an underlying medical condition and was very reluctant to be on site in the workplace. Now, the employer, because of the nature of the work that she did, felt that she should be. And essentially, this lady made a very strong case to her employer repeatedly that no, she could do her work from home. There were a number of other managers who could be on site, and she could take over that portion of work that didn't require to be done on site. The employer, though, was persuaded that really her presence on site was necessary. She resigned and took a constructive dismissal claim. Now, as it happens, she secured other work quite quickly after her resignation from the first employer, and so the award that she received was modest enough. I think it was in the order of about €7,000. But had she not secured that other work, the redress, the award that she might have been given could have been up to 2 years of pay. So just be very mindful generally if employees are seeking to have to work remotely, particularly if there are circumstances that apply, just to be seen to give it real attention. I'll just finish up then by mentioning very quickly a number of other employment-related initiatives that are in the pipeline that really have gathered momentum or have their genesis in COVID, I suppose. And the first to mention is the recently enacted Family Leave and Miscellaneous Provisions Act of 2021. And that, of course, enhanced the number of weeks of parents' leave from what had been 2 to now 5. But interestingly, it also now provides that a parent has up to 2 years during which they can draw down this parents' leave in respect of a child born on or after the 1st of November. And initially, listeners will be aware, that was to be a 1-year period. So the parent was to draw down their leave entitlement within 52 weeks of the child's birth. Because of COVID and the difficulty people had taking the leave, either because they were required to be on site following their period of mat leave, or just in terms of the fact that they weren't working anyway. They were on COVID illness benefit, or they were on PUP because they were on layoff. They had no facility to take that leave, and that 2 years originally was boxed off as something that they would be entitled to, but that now has been extended to all new parents. The programme for government then commits to progress a living wage over the lifetime of the government. And interestingly, the Taoiseach and Minister for Enterprise, Trade and Employment, Leo Varadkar, has stated that the pandemic has caused us to redefine frontline or essential workers and to reconsider the value we place on their work. So again, there is a group, the Low Pay Commission, are looking at this in some detail now. So that certainly, in terms of employers, is one to watch for the future. Other big ticket items, again, government proposal to introduce statutory sick pay by the end of 2021. And again, we'll be aware that there's no legal requirement for employers to pay someone while they are out at the moment, notwithstanding the fact that they may have an entitlement in their contract. But COVID, people who didn't qualify for company sick pay really came to the fore during the pandemic and really has placed a little bit of momentum under this space. And then finally, I suppose an issue close to all of your hearts, the Minister for Children, Equality, Disability, Integration and Youth, Roderick O'Gorman, recently recommending that a joint Labour committee is set up for the early learning and care and social age childcare sector. So as I say, I know that that is a topic close to a lot of SFA membership. So again, lots of developments in that area. Thank you very much. I'll hand back now to you, Ruth, if that's okay.
Absolutely. Good morning, everyone. My name is Ruth Heenan. I'm an executive with the IBEC Knowledge Centre, and I'm just going to speak to you a little bit today about occupational health and safety and what pieces we can look at practically, I suppose, to make your workplaces safer. So the first thing I'm going to talk to you about today is COVID-19 generally. So if we take a look at this slide, this is from the HPSC, and I just wanted to draw it to your attention because, of course, if you look at this, we can see the areas of Ireland in which we have the higher rates of infection. Okay, we can also look at the cumulative and number of confirmed COVID-19 cases notified in Ireland by notification date, which you may well be aware of, but you can also see the trends in the number of outbreaks and clusters in healthcare, childcare, school and workplace settings. So you can see that on a week-to-week basis. So it's a very useful guide, and it's available on the HPSC website. I thought that it would be worth drawing to your attention today. Now I'm going to come off camera so that we can focus on the slides here and move on then to the, now if we look here, we can see the workplace outbreaks. So if you see here workplace, I'm not sure if you can see that arrow, we see that the workplace outbreaks had a spike 2 weeks ago back up to 23 outbreaks. That has moved back down again, thankfully. So we've had 15 and 16 again this week, but it's one that's worth keeping an eye on. I suppose here in IBEC, we would be concerned that perhaps this is an underreported area where perhaps there are more outbreaks happening. And I'll speak to you a little bit more about how to handle one of those outbreaks in a few slides. The next thing I wanted to speak to you a little bit about today was just vaccinations. So this came from gov.ie, this table here, and we can see how the vaccinations are going in Ireland at the moment. Obviously, we are making progress, even if it's not quite as fast as we would want it, but it's a good table to keep an eye on in terms of not just what has already commenced, which we'd be well aware of, but also the anticipated times for when the next categories and groupings might come in. This is obviously important in terms of just, a reopening of Ireland and the return to work, but also in terms of planning for yourselves. If you anticipate that a lot of your colleagues may perhaps be getting the vaccine then in early June, you can be making plans for that and potential staff shortages. Some other news in relation to vaccines would include that 21.8% of adults in the state over the age of 16 have received their first dose, while 9% are now fully vaccinated, and that actually came from a couple of days ago, so it is higher than that again now. We have over 800,000 people having had their first dose and well over 300,000 having had their second dose, which is great. The other news, I suppose, being that AstraZeneca, the NIAC recommended that AstraZeneca should not be given to those under 60, of course, which I'm sure you'll have seen in the news, and also that Johnson & Johnson has delayed European COVID-19 vaccine rollout. But the EMA have said that the benefits of Johnson & Johnson COVID-19 outweigh the risks, which is great. The next thing I wanted to speak to you a little bit about today was the high-risk staff. So I know, look, you're probably in the midst of dealing with this at the moment, and you may be aware that anyone who is at higher risk of COVID-19 will either be deemed to be a high risk or a very high risk stroke extremely vulnerable person. Under the work safety protocol, you do have an obligation to ask your staff whether they are at higher risk or not. So look, if you don't have that done yet, now is the time to do that, and we do need to be careful with what we ask. We don't need to ask them for what reason are you or any of that, but just to ask them, do you have a reason to believe that you might be at higher risk from COVID-19, and make sure that that's been asked. There have been some changes in this area more recently, so even if you have kind of kept on top of this, just to flag those with you, because of course anyone who has been in that extremely vulnerable category, they were asked to cocoon. So you could potentially have quite a number of staff who are not at work at the moment based on their medical reasons. But that advice has changed, so it's no longer asking them to cocoon, but to stay at home as much as possible. So that is a subtle difference, but just to bear it in mind that this advice is changing. And the advice is available at the link that's below there, and these slides will be available, so you should be able to get that link after this. The other thing to think about in relation to the last two slides, I suppose, is that your staff are going to be being vaccinated. And so these staff who are extremely vulnerable, if we take a look back at the slide just before, we can see, that medically vulnerable people who are at very high risk of severe COVID-19 disease, that has commenced. And so therefore, this group of people may well be at less risk of COVID-19 at this stage. Now, the advice from government hasn't been updated to say that these people who have had the vaccine can come back to work or anything. I think we're quite a bit away from that, but it's worth keeping an eye on and thinking about how you will manage that return. And if those members of staff do approach you and say, look, yes, I was extremely vulnerable or very high risk, but I now have my vaccine, I feel I can come back to work. I think in that instance, the best thing to do is send them to a doctor, whether that be their own GP or ideally occupational health, and see if the doctor feels that it is appropriate for that employee to return to work. The next thing I want to speak to you a little bit about today are the travel restrictions. So firstly, the travel restrictions are all under this umbrella of the Health Amendment Act of 2021. But of course, I'm sure you're well aware that the advice on this changes all the time, and the statutory instrument does actually provide for that the changes will come in through the website. So we will see in that second link there, you have the travelling to Ireland during the COVID-19 pandemic. That's the best place to go to get the most up-to-date advice in terms of travel. So if ever you're dealing with this, that's the first place I would look, and I think it's the first place you should look to. It's on gov.ie. That explains that there are category 1 and category 2 countries. So the category 2 countries are what are known as designated states. And those are the countries where anyone returning from one of those who has been in one of those countries in the past 14 days, those passengers now need to attend mandatory hotel quarantine. That mandatory hotel quarantine, there is a lot of information again available on that on gov.ie. Again, the link is available there. But it is slightly unclear in terms of what is a category 1 country. So category 1 country is any country that is not a category 2 country. So if you check on the gov.ie website, you can find the category 2 list. If the country is not listed there, you can assume it is a category 1 country, and therefore that mandatory hotel quarantine won't apply. I'm not sure if any of you have had an issue more recently in terms of bringing anybody into the country, for work, but there is an issue at the moment in terms of our subject matter experts. So, people who are coming into Ireland because this work was not able to be sourced from somebody locally, and they're doing expert work in terms of fixing machinery, for example, repairing something, doing something urgent like that, or a member of an international organisation. These are examples of exemptions that had been available to anyone coming in to Ireland. So a passenger coming in who, fit into these exemptions could come in, would be put into a place of quarantine, but could leave to go and do their piece of work and then come back to the place of quarantine. It would now appear that only will apply to the category 1 country. So only if you come in from a category 1 country will those exemptions apply. And you may have seen IBEC in the media more recently, I suppose, trying to make the claim to government for why that needs to change and why those category 2 countries should also allow for the exemption to apply for subject matter experts coming in. We hope that there will be an update in relation to this, but for now that is the state of play. So just to be aware of that. If you do need to bring someone in, the next thing to think about, I suppose, are the risk assessments that will be involved. You need to make sure, firstly, that it is absolutely necessary to bring somebody into Ireland. And after that you can ensure that it will be safe for them as much as reasonable. So, those thorough risk assessments are the next best step to do. Also be aware that while you might be nervous of bringing someone in, the person coming will also be nervous, and that there will be a lot of communication needed to make sure that they feel safe coming into Ireland at the moment. Obviously, we have a tighter level of restrictions, and that can make people coming from other countries, which may be more open, a little more nervous. So it's just something to be aware of. And finally, the other thing I just wanted to mention in relation to this is that changes coming in relation to the mandatory hotel quarantine for those who are vaccinated. And again, the details of that are available on gov.ie, but to make you aware that, if somebody is coming in, check whether they have been vaccinated. For example, the United States is now on the category 2 list, and as I'm sure you're aware, the vaccination rollout is a lot further on there. So there's a good chance that the person coming may be vaccinated. So that's always worth keeping an eye on. The next thing then that I wanted to speak to you about was remote working. So at this stage of the pandemic, I suppose a year in, you may well still have people who are working from home. Now is a good time to think about the remote working policy that you have in place, whether you have one, whether you don't. It's time to put one in place, and there are a lot of reasons for that. But in terms of the OHS context, it's really important that you define the parameters of the workplace at home. If somebody takes a phone call, for example, and it's a work call and they're out in their back garden and they trip on a hose, let's just say, well, if you don't have the parameters of the workplace being, the surroundings, for example, of their visual display unit defined in your remote working policy, it's difficult to claim that wasn't part of their work. So it's really in your interest, I suppose, to get that policy in place sooner rather than later, or if you have one in place indeed, to make sure that you have defined the parameters of the workplace at home. I just wanted to flag as well that we have an IBEC flexible working toolkit, and I know that Lorraine has spoken to you a little bit already about hybrid working and you know, employees who may not want to come back to the office full time, or indeed may not want to come back at all and want to work remotely going forward. That IBEC flexible working toolkit has a lot of tips and tricks in it, and talks through a lot of the, you know, considerations that we need to think about. Even in terms of just the equipment and how you'll manage all of that. So it's really worth taking a look at. And if anybody has difficulty finding it, it's on our website, but feel free to get in touch and we can pass that on. In terms of remote working, the next thing I wanted to speak to you about was the risk assessment. So anyone who is working from home, you still need to have a risk assessment done for them. Now, there is a lot of information out there and resources to make this as easy as possible. The two that I've mentioned there, the HSA Guide to Working from Home and the Be Smart tool from the HSA, those are both really, really good tools in terms of trying to, you know, do this practically and efficiently and you know, also, you know, getting it done. So, you know, let's not delay on that. If you've had people at home for over a year, it is time to put those risk assessments in place. Finally, then, I just wanted to speak a little bit about the visual display units. So obviously there's the 2007 regulations, which you may be aware of, but those, you know, require that the necessary equipment, you know, would be provided for your employees. So if you're doing a risk assessment and you identify that someone has been, I hope not, but, you know, working on a laptop on an ironing board, or indeed just working at their kitchen table, which is very low down, and they're having neck problems or things, now is the time, you know, to take stock of that and think about the damage that is being done to your employees there and your duty of care to them. It may well be time to provide equipment. Now, I know that that can be, you know, quite a big expense. There are different ways of tackling that, but if, for example, you're looking at hybrid working going forward, and you imagine that at any one day you won't have more than, let's just say, 40% of your staff working, you know, in the office, or indeed 40% of staff working at home, well, then you have a bulk of your equipment which you know you won't need in the office all the time. You won't ever have 100% of your staff in the office, and that has made some of your equipment available. So you could, for example, courier it out. There are a lot of, I suppose, you know, tips and tricks that we can talk through in terms of how to make your employees safe and fulfill your duty of care to them without going to a huge expense. So that's worth taking a look at the moment. And the next thing that I wanted to speak to you about was the PPE, personal protective equipment, including, of course, the face coverings. And I know that this is an issue, particularly for yourselves at the moment. A lot of you may, you know, have a clear-cut line on this because you are what's deemed a relevant premises under the SI, and that would mean that, you know, you are obliged to have your staff wearing face coverings in these certain premises. That's a blessing and a curse, I suppose, because of course it solves the issue of, do we need to require face coverings or masks in our workplace? Yes, you do, and you can stand over that, and you have a reason for mandating the wearing of those face coverings. It also, I suppose, provides that obligation, of course, that the customers will wear the face coverings coming in, and I know that that is an issue for yourselves at the moment, and I would just, you know, flag that obviously there are equality concerns, and people may have what's known as the reasonable excuse for not wearing the face covering, and so it's important that your staff are, you know, trained in how to manage that situation and to balance your duty of care to your staff in terms of insisting that somebody wears that face covering with the fact, unfortunately, that somebody may have a medical reason not to wear that face covering. And I know that that's coming up quite a bit for yourselves at the moment. In terms of the rest of the members who might be on, you know, who are not under that relevant premises, okay, for you then you need to make the decision on whether or not you are going to mandate face coverings. So within the work safety protocol, it's where 2 meters of social distancing can't be achieved. That's where you're looking at, I suppose, that other precautions need to be put in place, and that is where I suppose the masks or face coverings might be more relevant. Aside from that, you may also need to require them based on your risk assessment. So if we're looking at risk assessments in this context, I've included here the hierarchy of controls. And of course, you know, the number one thing that we can look at is elimination. And for employees, if they can be working at home, that eliminates the risk of them passing COVID-19 to one another, because of course they're not meeting one another. And in level 5, anyone who can be working from home should. and we are still in level 5. And when we look at those outbreaks that we've seen and the levels of those, you know, potentially on the increase, even just the amount of traffic on the roads, it does appear that, you know, there are a lot of people at work at the moment. And maybe now is time to take stock of that and have a think about if there's anyone on site who, you know, even if it's a case of, well, we do need them in some days, but actually we could put all of the other work that they do together and keep them at home 2 days a week. Even if it's just that, take a look at it and see, because of course, in terms of controls and keeping people safe, elimination and substitution are, you know, the best two that we can look at. And when we come down the line, then we finally get to the PPE. So having everyone in wearing masks is not as safe as not having everyone in, I suppose, is the point that I want to make here. And that, I think, you know, can help in terms of if you have less people in, then everybody is further apart, and then hopefully some of your issues in terms of the face coverings might be mitigated, where people, for example, have a lot more space to themselves. I know that a lot of people are dealing with the refusal to wear a mask and employees having issue with that. So this really, you know, takes two paths, and one is where there is a medical reason for doing this. If there is a medical reason for the employee not wearing a mask, we then are looking at, you know, the equality concerns, and this employee should not be discriminated against. We need to reasonably accommodate for them, for example. And that doesn't mean to say that we have to allow them in not wearing a mask. If it's a case that, you know, you can't redeploy them to another piece of work and you have identified in your risk assessment that it is essential for this employee to be wearing a mask for it to be safe, well then, you know, you do have grounds there to either, you know, insist on wearing the mask or not have the employee coming in if they are refusing to wear it. But of course, the risks are much higher there because there is a medical reason for it and there are quality concerns. The other path that this can take is where there is not a medical reason for doing this. There really aren't quality concerns per se. And so we're really looking at, you know, asking the employee why they're not wearing the mask and potentially going down a disciplinary route for failure, you know, to complete a reasonable or to comply with a reasonable request. And I know that that is an issue that we are seeing coming into the courts now, to the Labour Court and to the WRC, just, you know, from those employees who from the get-go probably weren't wearing their masks. Those claims are starting to come through, so it's important to keep an eye on how those are going to follow through in the WRC and third parties. So that concludes my presentation as well. Emma, I'm not sure if you're available.
Hi Ruth, I am. Thank you so much for your presentation. If you don't mind, I have received a few questions that I might ask yourself or Ruth or Lorraine. One I received, and I know you've mentioned there, Ruth, just about the masks. I suppose from our side, myself and Fiona would both agree, look, that we're getting an awful lot of questions from our members asking, what do they do if a staff member just refuses to wear a mask?
Yeah. And look, I suppose, you know, it is coming up a lot, and the first thing again is just ask, is there a medical reason for this? And the path then, you know, as I did go through, you know, the path of what the employer should do are defined completely by whether there's a medical reason for this or not. And the medical reason, I suppose, just to flag, you know, that can be decided by the employee if you don't take control of it. It should be being decided by the doctor. So whether that's their own GP or occupational health, make sure that there is a certificate there, a medical cert that you can rely on for making those decisions.
Brilliant. Okay, thank you. This question now I think might be more for yourself, Lorraine. It's what about employees who fail to attend for work when our company reopens again for fear of catching COVID-19?
Well, I think, Emma, if people aren't presenting for work, obviously you have to establish what the reason is. If it is the case that they're saying, and this is akin to the question Ruth had there, if there's a medical reason, obviously, you know, so let's say that they are medically certified, maybe not vaccinated yet, or there's a view from their GP that they shouldn't yet return, then that's fine insofar as they've a reasonable justification there. But if it is the case that they're in the absence of their doctor saying they shouldn't be back, in the absence of the occupational health doctor believing that they shouldn't be back for medical reasons, then really I think it's a question of engaging with the employee, going to great lengths in terms of the fact that their presence is required, that you know, the nature of the work they do is essential. And, you know, the public health guidance is that it is permissible for them to be back, reassuring them about the measures that the company has taken to, I suppose, provide a safe workplace in line with the public health guidance. And I think really it's that process of engagement, but ultimately, if it is the case that the individual refuses to engage in particular, if it is the case that there is no justifiable reason for them not to come back, you may have to talk to them about invoking the disciplinary procedure and regarding them as being on an unauthorized period of absence. Now, as I say, all of that comes after a period of engagement, being reasonable, establishing what the issue is. But certainly, Emma, if there was any red flag that the individual felt that they were as financially as well off, you know, on the pandemic unemployment payment, and that was the obstacle to them returning, I think that would be a different matter.
Fantastic. I know I'm conscious of the time now, we'll be taking a break, but I just have one more question here. And I know I'll be touching on it later in my presentation with the HR update, but Lorraine, this might be for you. There's a question: on what grounds will an employer be able to decline an employee's request to work remotely when the new code of practice comes out on right to request remote working?
So Emma, that's the million-dollar question. We don't know yet, insofar as what we know is what's in place in the UK, where there are very set grounds on which an employer can decline. So it's still very much up for grabs in terms of the Irish code. And of course, the code is very persuasive. You know, even if it isn't a piece of primary legislation, any code of practice has is taken very much into account if the person takes a claim to the WRC or to the Labour Court. So generally, we're hoping that there'll be plenty of scope, you know, that when that code comes through, it'll be that the person's application is measured against the nature of the business, the work they do. So clearly, if I'm a retail assistant, I really can't do my work remotely. But then other issues in terms of, well, do you know, at a minimum, can an employer, or will there be something in the code that says you have to have a minimum number of months of service before you can apply for your remote working? Will we see it built into the code that, okay, if remote working is facilitated, if the nature of the work lends itself to it, that can be done on a pilot basis initially, you know, that we're not wedded to it for life. So in terms of the detail, though, we are likely to see some level of more certainty in the code when it arrives. But at the moment, because it's still at submission stage, stakeholders engaging with government in terms of their wish list, all of that has yet to be fleshed out, I suppose.
Fantastic, brilliant. Look, thank you so much, Lorraine and Ruth. Really appreciate your excuse me, your presentation today. I'd say our members will agree it was fantastic, and I know we're after getting an awful lot of questions in. We don't have time to answer them all. And look, we will do our best to contact you directly to answer those. And just I see one question I'm just going to answer here. Are the SFA going to issue draft of right to disconnect policy? So look, obviously the SFA do their best, you know, in giving sample documents and policies. We're working on a right to disconnect policy, and I'll just speak about that later in my presentation. But look, again, thank you so much, Lorraine and Ruth. Really appreciate you coming on here today. And I think, look, it's 10:30, so we'll be back at 10:45 for you can take a coffee break, go for a walk, and we'll see you in 15 minutes.
Thanks, Ella. Thanks, everyone.
Hello everyone, welcome back. So next on our agenda, we'll be speaking with Ananta. So Ananta is one of our employment law experts in IBEC's Knowledge Centre. So she's going to speak to you about employment permits and the key changes to the current employment permits and immigration permissions, and that's affected by COVID-19 and Brexit. So welcome, Ananta.
Thank you very much, Emma, and good morning to everyone on the seminar today. So I'll just share my screen here for everyone, and hopefully we can all see that. So today we will be discussing the employment permits and visa system in Ireland in the context of hiring non-EEA nationals. So there has been unprecedented change in this area recently and consistently over the past 2 to 3 years, which was very strongly underpinned by our tight labour market pre-COVID. However, unsurprisingly, there has been a significant shift in that, with our labour market, quite loose now, and the fact that our unemployment levels are at approximately 24.2%. So as employers and HR professionals, we have to be cognizant of that figure when we are seeking to recruit during this time. So I suppose without further delay, we might kick off with the agenda and look at the governing legislation in the first instance, and also the functions of the various departments or government departments that monitor compliance with this as well. So I will just come off camera and share my slides, and if there's any questions, happy to take them at the end. So when we look at the governing legislation, then it's the group of legislation that covers this area is collectively cited as the Employment Permits Acts from 2003 to 2014, in which the 2003 Act provides that a person shall not employ a foreign national in the state except in accordance with an employment permit granted by the Minister under Section 8 of the Employment Permits Act 2006 that is in force. Similarly, another very important piece of legislation, which is the Immigration Act, also cites that no non-national may be in the state other than in accordance with the terms of any permission given to him or her before the passing of this Act, after such passing by or on behalf of the Minister. And these citations of the Minister means the Minister of Justice. So therefore, when recruiting non-EEA nationals, an employer will be expected to comply with the Employment Permits Act, the Immigration Act, and all other employment-related legislation. And an important one there is the Employment Equality Act, due to one of the 9 grounds of discrimination in which race sometimes, is challenged when recruiting non-EEA nationals. So hiring a non-EEA national without the relevant right to work in the state may be detected in the first instance by a Workplace Relations Commission inspector who has remit to issue fines and convictions for non-compliance. So, as an employer, if you're wondering, if we've made an error in hiring somebody who doesn't have the correct permission to work, or they don't have any, this is the first instance where the risk would arise if you received a WRC inspection. And if that's the case, generally the inspectors in the first instance would give you time to comply with the relevant provisions of the acts or the piece of legislation. But if an employer can't adhere to that, then penalties may be introduced. So there's just a summary of the penalties under the acts. So on summary conviction, a fine not exceeding €3,000 and or imprisonment for a term not exceeding 12 months, or on conviction or indictment to a fine not exceeding €250,000 and or imprisonment for a term not exceeding 10 years. When it comes to compliance with rights to work, it is more, it is quite strict, and the fines are significant as well, where if you don't comply with other pieces of legislation, it's not as harsh, but they take this very seriously for obvious reasons. Then I suppose, again, as HR professionals and employers, when we are seeking to recruit a non-EA national, or if we have non-EA nationals employed, and to understand their permissions and rights to work and what government departments those employees may have to liaise with, we actually have to understand what each government department has responsibility for. So I'm just going to talk about the two government departments mainly that an employer may come in communication with when looking at permission to work for employees. So the first department we'll look at is the Department of Enterprise, Trade and Employment, previously known as Department of Business, Enterprise and Innovation. And their responsibility is to process and grant employment permits via their employment permit online system. And it's actually all done quite well through their website. They also have responsibility in identifying skills shortages and setting regulations for the critical skills and ineligible lists of occupations. And essentially what that means is, if as an employer we are struggling to find the right caliber of talent to engage in a job or a profession in your company, and you feel like, you know what, if we put this advertisement out worldwide, we may be able to attract candidates for this role. The thing is, before an employer can engage a non-EEA national in any role or profession in the state, they have to do that in compliance with the critical skills occupations list and the ineligible list of occupations. And what these lists essentially mean is that if there's a role placed on the critical skills occupations list, then the Department of Enterprise, Trade and Employment may consider granting a permit for that candidate you've identified. However, if the role that we're looking to source is placed on the ineligible list of occupations, then, you know, what the department is essentially saying is, we feel there is enough local talent either in the state or in the EU for you to be able to fill that role, and you shouldn't necessarily be sponsoring a non-EA national for that. So just prior to, you know, considering taking on a non-EA national into employment, it's very important to just double check those lists prior to doing that. And that's how they monitor skills surpluses and shortages in the state as well. Then moving on to the other government department, which is very important as well, it's the Department of Justice. And within that they have the Irish Naturalisation and Immigration Service, or you can refer to as the Immigration Office. So the Department of Justice maintain responsibility for immigration matters in Ireland through the Irish Naturalisation and Immigration Service, and they operate in line with the Immigration Acts, and their main responsibility is to process and grant permission to enter the state. When a non-EA national, you know, lands in the state or travels to Ireland, they also consider their reason for coming to Ireland. Are you coming here for work, to study, for holidays? And in accordance with that, they will issue the visas and stamps, which may or may not allow an individual to work. So just as a recap, I suppose, when we're looking at the Department of Enterprise, Trade and Employment, they are responsible for granting employment permits only. And when we're liaising with the Department of Justice, or INIS, they predominantly look at granting stamps and visas. Now, on occasion, there is overlap between the two departments and permissions, but for the main part, you know, if you go to the wrong department, they won't be able to help you out with the permission that you're asking about. So Then I suppose if we just take one step back and go back to Department of Enterprise, Trade and Employment and the processing of employment permits. So if we are seeking to sponsor a non-EA national to come here and work, they may be eligible for one of the 9 employment permits that are in operation. Now, for the purposes, I suppose, of the seminar, we will touch on the 3 permits that are more commonly circulated in the labour market. So the others, the information on the others can be found on the Department of Enterprise website, and there's good information on there for that. So if we look at the first type of permit anyway, it's the General Employment Permit. And a criteria of this permit is that if you want to engage a non-EA national in employment, that you have to guarantee a minimum annual remuneration of at least €30,000. It can be €27,000 for non-EA students who have graduated in the last 12 months in Ireland. However, a caveat of this type of permit is that a labour market needs test applies. So those of you who may be familiar with having done that, you'd understand, you know, what this involves. But essentially, it obliges the employer to advertise the vacancy with the Department of Employment Affairs and Social Protection on the EU RES employment network for at least 4 weeks or 28 days, and also in a national newspaper for at least 3 days, and in either a local newspaper or jobs website for 3 days. So it's quite robust in terms of, you know, demonstrating that the employer has exhausted all avenues to source a candidate at a local level and at an EU level before they will consider granting an employment permit for a non-EA national. So that's just a test which is part of this type of permit. The advertisement must also include a description of the employment, the name of the employer, minimum salary, location and hours of work. And the part where most employers or candidates, you know, fall down on when this type of permit isn't granted is the labour markets needs test. So it is an important criteria of it. The next type of permit, again, very common and is in great circulation in the state, is the Critical Skills Employment Permit. This type of permit is designed to attract highly skilled people by encouraging employment and permanent residency in Ireland. The employer must make a job offer of at least 2 years, and actually the employee or the candidate must also remain with the employer for a minimum of 12 months before they can consider changing roles as well. So it gives security to both parties to some degree. And eligible occupations under this type of permit are generally where there are established skills shortages in the labour market. And for those occupations, they're then placed on that critical skills occupations list. The expert group on future skills needs determine the roles to be placed on the critical skills occupations list. So that's just what involves initially with the critical skills permit, but then there's further conditions attached to it as well, which are that the candidate or the employee must be earning over €64,000 if the role is not specified on the critical skills occupations list. So as an employer, if you feel like, you know, we can't find talent in Ireland or in the EU, and the job is not listed on the critical skills occupations list, but we really would like to sponsor this candidate and bring them over, you know, if the salary meets €64,000 or above, a critical skills permit may be considered by the department in that case. For all other circumstances though, for a role that is on the list, the employee must be earning between 32,000 and 64,000, and the fee to apply for this type of permit is €1,000, which can be funded by the employer or the employee themselves. There are significant advantages to this type of permit, which is that there is no labour market needs test required, like with the general employment permit. The candidate or the employee receives immediate family reunification, so they can travel over with their spouse and dependents, and the employee would have a quicker route to long-term residency, meaning that after completing their 2 years on this type of permit, they can then move on and seek stamps, so a stamp 4, which gives them, greater residency rights to remain in Ireland. So it's definitely the more lucrative type of permit that candidates would like to be on anyway. And then I suppose the third type of permit that we're going to talk about during the seminar is, well, it is the dependent partner spousal employment permit, but just by way of information, the Department of Enterprise and Department of Justice have changed the rules for that type of permit. So what they're trying to do is phase out that permit, and in replacement of that, they've introduced a stamp 1G. So what used to be called a dependent partner spousal employment permit is now a stamp 1G. And essentially what that means is, where I talked about that the critical skills permit holder can bring their family over to Ireland if they're successful in being granted the permit, that family member used to be able to apply for a dependent partner spousal employment permit, but now they can avail of a stamp 1G instead, which allows them to work in Ireland without any great conditions. So they can work up to their 48 hours per week, they can engage in any profession, so they're not actually bound by the critical skills or ineligible list of occupations. And it's solely by virtue of the fact that they have come to accompany their spouse or de facto partner who is a critical skills permit holder. However, as an employer, this can cause confusion, because those of you who might be aware, a stamp 1G is already in circulation in a different format, because a stamp 1G is granted to a non-EEA graduate of an Irish university, which allows them permission to work. But now it's also granted to a spouse or de facto partner of a critical skills permit holder. So I suppose if you're recruiting for a role and a non-EA national presents you with a stamp 1G, you might just want to double check, well, why do you have the 1G? Is it because you're the spouse or de facto partner of a critical skills permit holder, or is it because you are a non-EEA graduate of an Irish university? So that's just that on the permits side of things. Now, as again, unsurprisingly, there has been a huge impact on the processing of employment permits, the renewal of employment permits and things like that because of COVID and the travel restrictions. But notwithstanding, the government departments have actually introduced temporary measures to ease the challenges for employees who may be on employment permits. So the Department of Enterprise, Trade and Employment has implemented a contingency plan to ensure that the employment permit system will continue to operate in all scenarios for the duration of the COVID-19 crisis. And the most up-to-date information can be found on their website. So essentially what they're saying is that even during COVID and the travel restrictions and all of that, employment permits are continuing to be processed for visa and non-visa required countries. However, additional options are available to employers and prospective non-EEA employees should the employees be unable to travel to Ireland due to non-issuance of a visa from the Department of Justice. So it's twofold. So if you do identify a non-EEA national who you want to sponsor and bring over to work in Ireland, the first thing is that they will or may require an employment permit to come and work for your organisation, but also that if they are travelling from a country that is a visa required country to land and enter Ireland, that they have to liaise with two departments, the Department of Enterprise, Trade and Employment and the Department of Justice. So what's happening at the moment is, because of the robust travel restrictions, visas are actually not being processed for individuals unless they are coming in for priority or emergency cases. So what employers are finding is that the employment permits are being granted for the candidates or for the prospective employees, but they're not getting a visa to travel here. So in that case, that's where the Department of Enterprise has implemented temporary arrangements where, you know, employers can request for the permit to be temporarily ceased or for a new application to be submitted. So those supports are available, and that's why it's just important to link in with their website if you're in that type of situation. So then just moving on to the Department, or switching again to the Department of Justice and what they have introduced as part of their contingency COVID arrangements. So this one is it's more important because you may have employees, or you may be looking to hire employees who are on visas and stamps. So you may have employees on a stamp 2 visa, for example, or stamp 1G or stamp 4. So what's happened there is, because of the COVID restrictions in the state, the immigration office has been closed for a significant period of time. So employees whose visas and stamps had expired, meaning their right to work had expired, they couldn't actually go and get renewals for them, which left a gap in which the employer would consider, well, you know, your permission has expired, can I let you work or not let work, and things like that. But to kind of support that, the Department of Justice has said that there are further temporary extensions of immigration permissions, meaning that any permissions that are due to expire at the moment between 21st of April 2021 to 20th of September 2021 are automatically extended. So the previous permission that the employee would have been on, for example, a stamp 2, if that expires, you know, this month, then that's automatically extended to 20th of September 2021. So this isn't the first time they've introduced it, it's the 7th time. So actually, since last March, a lot of employees have been just rolling on these extensions, and they haven't managed to maybe get an appointment to get a renewal. So that's just a bit of support for non-EEA nationals whose visa and stamp permissions have expired. Now, the Minister has said, and on occasion previously, that this is the 7th and expected to be the final extension of permissions implemented since the outset of the pandemic, and the longest granted. However, it is benefiting tens of thousands of people. But if there's any situation where, you know, you're finding it difficult to interpret this, please just ask a question and we can go through it. And then I suppose, again, sticking to then the Department of Justice, just by way of information and awareness, especially from a recruitment perspective, we have to understand what types of visas and stamps are in circulation as well, so that we don't hire an individual on a type of stamp that doesn't allow them to work. So some stamps or visas allow an individual to engage in employment and others do not. So therefore, just very quickly, we might just go through the types of stamps and visas in operation. So if we're looking at a stamp 0, it's a temporary and limited permission. If an individual presents a stamp 0 at recruitment stage, it doesn't allow them an automatic right to work. So they're not permitted to work. They may be eligible to remain in the state for exceptional circumstances, for example, if they're hospitalized, but it's not a right to work at the outset. A stamp 1 then, if you're looking at a stamp 1 during recruitment, there's no automatic right to work unless it's accompanied by an employment permit. And again, that employment permit should be for your organization, but not one that they have brought over from their previous employment. Or it should be accompanied by a letter of approval by the Minister for Justice, or that it's accompanied by a working holiday visa. So it's only in limited circumstances where a stamp 1 may allow a permission to work, but in isolation, you wouldn't take it as a right to work. A stamp 1A then, So holders of a stamp 1A are permitted to remain for the duration of his or her on-the-job training as full-time trainee accountants. And this is very specific to the profession of accountants, and it's only granted for 4.5 years. A stamp 1G then, as we've kind of touched on already, is traditionally granted to a non-EA graduate of an Irish university, which may allow them from 12 to 24 months permission to work, but it is also granted to a spouse or de facto partner of a critical skills permit holder. Stamp 2 then, which you may be very familiar with, is granted to non-EA full-time students. However, there is a restriction on hours of work, whereby they can only engage in employment for 20 hours during term time and 40 hours during their college or school holidays. A stamp 2A then is granted to a full-time student in a course not recognised by the Department of Education and Skills. So these may be non-EA students who are enrolled in English language schools, for example, as opposed to, you know, in a college or university. A stamp 3 then just entitles an individual permission to remain in Ireland, but it doesn't infer a right to work. So just to be careful of that one. And a stamp 4, probably the most, well, not the most, but one of the most lucrative type of stamps an individual may be on. It can be granted to a holder of an expired permit. Like I said, if somebody was on a critical skills permit for 2 years, they can seek to move on to a stamp 4 then. It is also granted to a spouse or dependent of an Irish or EEA national, or somebody who has been granted refugee status. So that's just a background of the types of stamps that are in operation, and to be familiar with them for recruitment and compliance purposes. Now, there are other types of work permissions that kind of sit a little bit outside of the traditional employment permits and visas and stamps. And again, you may be familiar with these already. But one of these types of permissions is the working holiday authorization. And this one is managed by the Department of Foreign Affairs and Department of Justice and INIS. So this type of permission allows young people from certain non-EU countries to work in Ireland for 1 year. And Ireland's working holiday agreements with other governments allow young people of both countries to fund an extended holiday through temporary work. So it's like a bilateral J1 agreement, if you think of it like that. There's no limit on the hours of work that a non-EA national can do when employed in Ireland under this type of permission. And it's applicable just to the following countries that are listed there. So it works both ways. So young Irish people can, or young people from Ireland can go and, you know, live and work in any of those countries for a period of 1 year. And similarly, people from any of those countries can come here and fund an extended holiday. But it has helped out some employers in the situation where they find it hard to source roles at a local level, and they can, you know, engage non-EA nationals on working holiday authorizations for up to 1 year. So it's a good one that's in circulation. And then I suppose the last type of permission that we'll be looking at is the labour market access permission. And there has been more awareness of this one of late. You might have heard it on the radio recently and things like that. So essentially what it means is that the Department of Justice and Equality back in 2018 made a decision to allow people living in direct provision or people that are seeking asylum in the country to enter the labour market. And this is governed by the International Protection Act of 2015 and the European Communities Reception Conditions Regulation of 2018. So essentially, the labour market access permission allows international applicants to work while they are waiting to see if they qualify for asylum or international protection. The initial permission is for 12 months, and it can be extended every 6 months until the applicant receives an outcome on their protection. And employers are required to inform the Minister of Justice and Equality within 21 days from the date the applicant has been employed, and same for when the employment is ceasing. And the employers are requested to retain the following information. So the record of employment, duration of the employment, particulars of the labour market permission, and details of the remuneration paid. And we must keep this for a 3-year period. Now, I suppose the good thing of this type of permission is it's not subject to a labour markets needs test like the general employment permit is. It's not, an employer isn't tied into a remuneration package where you have to give at least 30 or offer at least 30,000 euros or 64,000 euros. You know, you can employ them on the market value of the role, essentially. And there's no compliance with any critical skills occupations list or anything like that either. So again, if an employer is struggling to source Irish nationals or EU nationals in a role, this is one that's in circulation. But the important thing is, and why there's more awareness about it of late, is because when somebody presents a labour market access permission at recruitment stage, it looks slightly different to what a stamp or a permit would. It's a letter which is watermarked on headed paper, well, Department of Justice headed paper. It should have the individual's image on it, and these conditions should be cited on it. So it's just, if you come across that, it is a right to work, and not to be taken as a non-right to work, I suppose. So that's on the immigration and permit side of things and work permissions, but we'll very briefly just look at the Brexit impact of late. So as you may be aware, UK citizens continue to enjoy arrangements under the Common Travel Area, including the freedom to live in the state following Brexit. And similarly, Irish citizens enjoy those free movement rights to travel to the UK and reside in the UK without any additional conditions. However, where the complexity arises is where UK citizens wish to be accompanied by a non-EEA family member to travel to Ireland and to live in Ireland. So UK citizens do not have an automatic entitlement to have a non-EEA family member reside with them in the state. And to kind of, elaborate on those conditions, the Department of Justice has issued a comprehensive policy document on how a pre-clearance scheme operates when a UK national has come to live in Ireland after the 31st of December 2020 and wishes to be accompanied by a non-EEA family member. Essentially, if that non-EEA family member, has a passport which is from a jurisdiction which requires an entry visa, they may need to apply for a visa to come here. So that is in operation and was in operation prior to Brexit anyway. But to make things a bit easier for the UK national who has this non-EEA family member, they've just introduced a comprehensive policy document which you can refer to following this link here. So then, just to recap everything and best practice measures for employers, it's advisable to keep up to date with the changes made to the permit system and visas and stamps by reviewing the relevant government department websites regularly. And as I mentioned, both departments have published their COVID-19 contingency arrangement FAQs, which are always subject to update. And I suppose that the challenges at the moment are from employers in the sense that they have non-EEA national employees who may have travelled back to their home country during COVID and they're either struggling to come back or don't want to come back. But again, that has to be considered in line with the business needs, how an organisation can accommodate and facilitate that, but also the wider implications that if we facilitate a non-EEA national to continue working from home abroad, that, how is that going to impact their visa and permission or permit that they're on here? How is it going to impact their contract and other employment law entitlements? and also from a taxation perspective. So there's a lot there to consider before, I suppose, facilitating long-term working from home abroad. But again, I'm happy to take questions if there's any on that anyway. But that's it from me, and thank you very much for joining the seminar and for this topic.
Thanks, Ananta. We really appreciate you coming on to speak about this. Look, you are definitely the employment permits guru, so look, I do appreciate you. You know, you've been on our seminars before. Look, we did get an awful lot of questions now on that presentation, and we won't be able to answer them all. I just reading through some of them have already been answered just throughout your presentation, but I have one here that you might be able to answer. So, can we hire a non-EEA national whose current permission to work has expired?
Yes, you can, and that is subject to you know, the employer relying on the temporary extensions that are in place that I briefly spoke about. So, for example, if this employee has been on a stamp 2, a stamp 4, or a stamp 1G, any one of those working stamps, and that has recently expired, and by no fault of the candidate, they can't obtain an appointment online to get renewal for that, an employer and the prospective employee can rely on the temporary extensions to engage in new employment. But just be aware to check the fact that they were on a working stamp or visa prior to that, because it's extended on that same basis.
Fantastic, brilliant. Another question we got in, I suppose it says they're sponsoring a non-EEA candidate for an employment permit. The permit has been granted, but they are unable to travel to Ireland due to the INIS not issuing an entry visa. Is the permit invalidated because the employee cannot commence employment on the start date?
Yeah, so that is a big concern for employers, in the sense that, you know, the permit is granted and it has a clear start date on the permit, but the prospective employee, through no fault of their own, can't travel, whether it's restrictions in their home country or it's travel restrictions introduced by the Irish government. In that situation, the Department of Enterprise are actually quite sympathetic towards employers and the employee. So what they will consider, and it's about reaching out to them in that situation to say that, look, can we keep that permit that's been granted on hold and give you a new start date, so the permit resumes from that particular date, or can we cancel it for the time being and obtain a refund, and then we'll make a new application when the person is allowed to travel. So those mechanisms are available for employers if they're finding that one type of permission is granted but the employee can't avail of a visa to come here. Okay.
Brilliant. Thanks, Ananta. Look, I'm just conscious for time. Look, as I said, there are other questions that have come in, and what I'll do is I'll make sure that I'll pass them over to Ananta and make sure we do get back to you directly. But I really appreciate your presentation today, Ananta. Thank you so much.
Thank you. Thank you.
So, look, I do hope everyone's enjoying the seminar so far. Next, we have Fiona Mulligan. She'll be presenting her piece on probation. So Fiona is Childhood Services Ireland HR Executive. So she'll be speaking about the probation period. She'll look at case law and she'll go through a step-by-step guide then on how to manage this period of probation.
Good morning, Emma. Thank you very much for the introduction. I just want to make sure that, can you see my slide deck?
Yep, that's perfect.
Great. Okay, perfect. Great. So lovely. We'll make a start. So thanks, Emma, for that introduction, and good morning, everyone. Thank you very much for joining us today. So I'm going to be discussing the probationary period with you all this morning. So we would receive quite a lot of queries surrounding this topic. So I'm delighted to have the opportunity today to be advising you all on how you should be managing this period of time. And I do hope that this presentation, gives you some advice that you can take away with you today. So I might just take off my camera so people can just focus solely on the slides. Great, perfect. Perfect. Is that moving over, Emma? Great, no, perfect. I think we have it there. Lovely. So great to start off. So the agenda for this morning is as follows. So firstly, we will go through the probationary period. So we will go through the function of the probation, the importance of having a probationary clause and what it should include, and common misconceptions that employers have. We will then delve into how you should be managing the probation. So we will be having a look at the employer's obligations, the importance of having a paper trail, and best practice when it comes to managing this period. Next, then we will review the 3-stage process that we would recommend if you are experiencing a problematic employee during probation. And then we will have a look at recent case law pieces regarding probationary dismissals. And then lastly, at the end of the presentation, you will have an opportunity to ask any questions that you may have or may arise during the course of the presentation. So great, so we'll start off with the first section of the presentation. So firstly, what is the function of the probation? So it is a period of time that allows the employer to evaluate the performance, conduct and capability of the employee. It also gives the employer an opportunity to determine suitability, so to ensure that both parties, are a good fit for each other. And it is important as well that the employer is providing training to ensure that the employee can successfully perform in the role. And then lastly, the probation, is in effect an extension of the recruitment and selection process. So probation is essentially designed to prove that both parties made the right decision during the recruitment process. So in terms of the employee becoming recruited and the employer in regard to the selection decision that they made. And just to make note here as well, I would quite commonly get this question from members in regards to how long, should you be having your probation for. So there is no legislation that determines the length of the probation. So generally most businesses will have a probation in place for an initial period of 6 months. And then they would include the clause to extend it. However, it's really, really important to bear in mind that it should never exceed 11 months, as the employee is covered by the Unfair Dismissals Act if they have 12 months or more service. So then on to the next slide, we're going to have a look at the contract of employment and what it should include in regards to the probationary clause. So the employment contract should really have a defined timeline whereby the employee is going to be monitored, which is similar to a trial period. And it's really important to remember, when it does come to probation, probation does work both ways. So the employee is expected to learn and adapt during this period, and equally the employer is obliged to provide training and support when required. So first off, that the contract should have a probationary clause. So essentially the probationary clause will allow the employee to know how long this trial period is going to be, before they're confirmed as permanent. And within that probationary clause, they will be fully aware as to how, this period is going to be managed. So within that probation clause, you should include the purpose. So the purpose of the probation is essentially to monitor and assess the employee's suitability for the role. The length of the probation should also be outlined, which is generally, as I said a few minutes ago, it is generally a period of 6 months. So probation periods of longer than 6 months duration should only really be used where the role is very complex and the employee cannot be exposed to the full range of duties within that time. And another very important piece, when you are drafting up your probation clause, is that you do include the discretion to extend the probation as an express term within the probation clause. So, for example, if you're unsure whether, an employee should pass their probation or not, or maybe the employee, you believe that their standards can improve by the agreed date and they have the potential to meet the required standards, you should be exercising the extension of the probation. And the clause should also reference how the employee's progress is going to be reviewed and that the employee will be fully appraised as to what the outcome of these reviews are. And just to further elaborate on this point, it's really, really important that these reviews are taking place. And I have come across situations whereby, no reviews take place during an employee's probation. And if this happens, the employee will automatically be deemed to have successfully passed their probation at the end of that term. So it's really, really important that you do follow through with these reviews. And then lastly, within that clause, it should also make note of the termination and notice period, which is generally 1 week or under the minimum notice in terms of Employment Act. So then on to the next slide. So a common misconception amongst employers is that, if an employee on probation isn't performing well and, things aren't working out, that the employer believes that the employee can be dismissed without regard, so that they can essentially ask the employee to leave with immediate effect without informing them of the reasons for the dismissal or even giving them an opportunity to improve or work on the concerns. So this is absolutely not the case. This approach can leave the employers exposed to a potential claim, and it's really important to be aware that employees on probation are entitled to fair procedures and natural justice. And while, the employee may not have the necessary 12-month service to avail of the protection of the Unfair Dismissals Act during their probation, they do, however, have protection and can take a claim for unfair dismissal under the Industrial Relations Act, which does not require any minimum service to pursue a claim. And then along with this, employees are protected from discriminatory or equality dismissal under the Employment Equality Act, and they're actually covered by this act from the very first day of their employment. They also have recourse to the Safety, Health and Welfare at Work Act, which again has no service requirements. And then lastly, that's outlined here is that they can take civil court action for breach of their contract of employment or wrongful dismissal during their probation. And again, there's no requirement to have the accrued 12-month service to avail of this. So based on this, employers should be really aware that, dismissal is absolutely possible during probation, but it doesn't give the employers a free will to act as they please. And what I should have mentioned there as well, there is the risk of reputational damage that would be involved if you were exposed to a claim. So I've seen this happen maybe through word of mouth, or, it could be maybe on an online employer review site as well. And then just actually while I'm on this slide, I might just note here as well, I would quite commonly review contracts of employment for our members. And I've seen many probationary clauses whereby the employers do state that their disciplinary procedure doesn't apply to employees on probation. And I suppose in conjunction with the fact that the employee is less than 12 months service, some employers do believe that they can, disregard their disciplinary process during a probation. However, from previous case law, it is evident that the employer's regard for the rules of natural justice, which I will be speaking about in a few moments, and their application of a fair procedure to employees will be scrutinised in the event of a probation dismissal claim. So it's really, really important to bear this in mind, and the fact, that there is risks involved there when you are dismissing an employee on probation. So then on to the second section of the presentation, we're going to have a wee look at how you should be managing the probationary period. So firstly, we're going to have a look at the employer's obligations. So very important is that employees should be receiving their probationary clause, which is generally outlined within their contract of employment, or I have seen it, within a probationary policy that's outlined in a company handbook. So that probationary clause should be robust and contain all of them details that I just went through there a few minutes ago at the start of the presentation. And then another obligation is fairness. So fairness is absolutely key when it comes to managing employees on probation. So an employer needs to ensure that there is fair process during the employee's trial period, that you as an employer is giving clear feedback to employees. And if there is an issue there, that you are giving the employee the opportunity to improve when it is needed. And that support element is really, really important. You need to ensure that you're giving adequate trainings and supports to the employees. And if an issue does arise, or maybe the employee isn't performing to the right standards, it's really, really important that you highlight it to the employee and that you give them a fair amount of time to show improvement. And then the next is the communication piece. So this is another important point. So communication needs to be happening very frequently and very often. And it needs to be very clear to the employee what your business's expectations are and how the employee is performing in line with these expectations. And then on to the next point. So concerns or issues really should be flagged at early stages, and the employee should be fully informed if they are not performing to the required standard. So if issues do arise during the probation, the employee should be given, an opportunity to improve. So we're really reiterating on that fairness piece here. And then lastly, in situations whereby, the probation is going to be extended, the employee needs to be informed in adequate time. You do require a good reason to do so. So you have to have a substantial reason as to why you're extending that period. And it's very, very important that there is a paper trail of all conversations or meetings that led to that decision of extension. And that will actually bring us into our next slide. So before I actually worked in HR, I was in a team leader role, managing a team of people, and I remember, encountering my first problematic employee on probation. And I remember going to the HR manager at the time and, trying to seek some advice off him in regards to, what was the best way to manage this employee. And he gave me a piece of advice that day that stuck with me throughout my HR career. He said, Fiona, look, when it comes to managing employees, and especially if they are problematic, he really reiterated the importance of having documentation of all conversations, that you're having with them employees. He said, if it's not in writing, it didn't happen. And this advice really stuck with me throughout my career. And it is a piece of advice that I do pass on to my members as well. And I am fully aware, that it is quite common for the majority of employees to successfully pass the probation with little or no issues. But in the event that you do have an employee that would potentially fail their probation, the burden of proof is on you as the employer as to why, you're making that decision. So you will need to have the ability to prove that you gave the employee a fair process, that you made the employee aware of what the issue was, and you gave them time to work on them issues. And again, when you're giving them that time, you need to show that you gave them a reasonable amount of time to work on those issues, and that you as the employer fully supported them during that process. And essentially you need to prove that that process continued up until a final decision was made. And without that paper trail, you're relying on a verbal conversation between you and the employee. And it's natural enough when you discuss something with somebody verbally, I might pick up something differently, or maybe the other person might pick it up differently. So the employee could absolutely argue the fact that your feedback that you get to them wasn't clear, but you might argue the contradictory in the fact that you made it really, really crystal clear to the employee that they were at risk of not passing the probation. So that really does, reiterate the importance of having that paper trail. So next then we have some practical steps here in regards to how you should be managing the probationary period. So firstly, have clearly defined the expectations. So you need to ensure that the employee is fully aware of what is expected from them, so that they can understand what exactly they need to do in order to successfully pass the probation. The next piece is that you should be having informal weekly or bi-weekly meetings with the employees. So these meetings are a really, really good tool to help the employee feel supported, and it is an opportunity whereby issues can be addressed by both parties. So the next point is to make sure that you're keeping records. So all discussions should be documented. So these may be needed at a later stage if the employee fails to meet the agreed standards. And then the last point here is that employers should be facilitating formal reviews. So say, for example, you have an employee on a 6-month probation. Ideally, you would be having them reviews maybe at month 1, month 3 and month 6. So these are a really, really good tool used to check in with the employee to see how things are going. And after these formal reviews, it's really important that you follow up with the employee afterwards in writing, confirming them key elements of what was just discussed during that meeting, so everything is clear for both parties. And then lastly, just on this slide, to highlight a frequent piece of advice I would give to my members, and I think it's really important when you are managing employees on probation, is that, you know, if issues do occur throughout the probationary period, you should be addressing them and you should be documenting them straight away. So don't wait for them issues to happen a number of times before you address it, or, you know, be waiting to think that, oh look, I have a meeting with Fiona next month, I'll just wait to address it with her then. You need to be doing it there and then, and it's really, really important that you take the manner of being proactive when you are managing employees on probation. So next then, as I mentioned there just a wee minute ago, you should be facilitating formal reviews. So say that probation is in place for 6 months, you know, you should be having your formal reviews ideally at month 1, 3 and 6. And it's really, really important that these, you know, formal reviews shouldn't just be a box ticking exercise or something that you just need to do. You should be looking at this as a long-term investment in your business. So the probation period is, you know, used to ensure that you have the right people within your organisation. And I'm fully aware that, you know, as small businesses or maybe service providers, you mightn't have the HR support that would normally deal with the people management element within your business, and you probably have to do this yourself, and time constraints may be an issue. However, I would really consider this as time well spent and invested. So for these particular reviews, you really should have an accompanying probationary review form for each of the 3 periods. And again, you know, it's important to be aware that these formal reviews should really only be a summary of the feedback that you have been given to the employee over the duration of the probation. So say for example, we have the initial meeting at month 1. So, you know, what does this involve? So essentially, you know, during this meeting, you should be checking in with the employee to see how things are going with them. You know, find out, is the role as they expected it to be when they went for the role? Is there training or support or anything else that they need to help them during that settling in phase? And it's a great opportunity for you to be given feedback. So if you have noted any issues at all, it's really important that you do highlight them to the employee. And you should be setting objectives or goals with the employee during this meeting as well, and making them fully aware as to, you know, how their performance will be monitored and measured and how frequently this will be done throughout the probation. So after this meeting, you should follow it up in writing, highlighting the key points that were discussed and agreed. And then just to note here as well, all probation review meetings should really conclude, you know, by reminding the employee that they are on probation, that failure to pass the probation may result in their employment being terminated. So it's really, really important that this piece is included so that there's no doubt in relation to what could occur if they don't perform to your expected standards. So next then we would have the first probation review. So this could happen maybe around month 3. So you would ask the employee, you know, what is going well for them within the role, what isn't going so well, and it's important that you're giving your feedback in regards to these points as well. So as you set them goals in the initial meeting, you know, you should be discussing the employee's performance against them goals that you would have agreed during that initial meeting, and see if the employee has encountered any problems within the role. And again, it's another opportunity to address any matters of concern, you know, that you may have, and we would reiterate that supportive piece as well. So make sure you offer an additional training or support if the employee needs it. And then, you know, if this is month 3, realistically, you will know if the employee is on target to pass their probation or not. And if they're not, you shouldn't be waiting until there's a scheduled meeting to make the employee aware of this. You need to address the issues as they arise during the probation. So say, for example, an issue arises or comes to light on month 2, you should be arranging a review process or review meeting pretty much straight away, highlighting the issues and reiterating your expectations, as opposed to waiting to that review that you know is going to be happening at month 3. So then lastly, then you would have the final probation review meeting. So essentially this meeting is an assessment of the employee's performance throughout the probationary period. So after the review, you should assess if the employee has successfully completed their probation or not. If the employee has not achieved the desired standard in completing their probation, you have two options here. So you can either extend the probation, and in situations whereby you're going to exercise this, the employee needs to be informed in adequate time, and you do require a genuine reason as to why you're doing that. And I know I'm probably repeating myself at this point, but it's really important that there is a paper trail, of all conversations or meetings that can back up as to why this decision of extension is being made. So you should really only be extending the probation if you believe that the employee has the potential to improve to your satisfactory standard, or if they haven't had sufficient time or support or training to complete their objectives or goals within that trial period. So in order to do it correctly, you need to confirm that the extension in writing to the employee, so specifying how long that extension will be, and along with that you should be outlining the reasons for the extension and confirm whatever objectives are going to be reviewed during that extended period. And then if you were to go with the latter option of terminating the employee, it's termination during a probationary period should never come as a surprise to the employee. By the time you come to that decision, the employee should have been informed that they were at risk. So the key word there is you had informed them that they were at risk, and they should understand why this decision of termination is being made. So you need to ensure that you're given substantial and concrete examples whereby the employee failed to meet the required standards, and the employee should be allowed to respond and state their case. So all of this should be taken into account before a decision of termination is made. So next then we're going to have a look at how you should be managing problematic employees. So what should you be doing, if there's an ongoing problem with an employee during their probation? So these different issues could be maybe performance related, it could be, their behaviour or conduct, or maybe it could be an attendance issue. And as I mentioned earlier, many employers do state that the company's disciplinary procedure doesn't apply to employees on probation. However, we would advise that organisations should be fair and follow their own disciplinary procedures to manage, any issues outlined with the employee. But it's not necessarily required to use the full disciplinary process for employees on probation. However, you need to ensure that you're adhering to fair procedures. So if this is the situation, the employee should be aware that, the matter of concern from an early stage, so you need to highlight it to them at an early stage and make sure they know that it isn't to the required standards. They need to be given the opportunity to improve, so to make sure that you are giving them, you're realistic in terms of when you expect to see improvement. That you do give the employee the necessary support to show improvement. So if any additional training or further support is needed, make sure that you do offer it and make sure that the employee does avail of it. And then lastly, then employees should be aware that if they don't improve, that their employment could be terminated. And from looking at previous case law when it comes to probationary dismissal claims, the case law has demonstrated that employers have fallen far short of what is expected in relation to the principles of natural justice and fair procedures. So it's really, really important to bear this in mind and take these points on board. So then we are moving on to the next stage of the presentation. So we're going to have a wee look here at the formal 3-stage probationary disciplinary process that could be applied when you are managing employees who are either underperforming, have conduct or attendance issues. And also to make note here, you can absolutely, shorten the following process for more serious cases, such as maybe an incident of gross misconduct with an employee on probation. So we'll make a start. So here we have stage 1. So this is the needs to improve stage. So, you would be invoking this stage if it was a situation whereby an employee requires to show some sort of improvement. You might have already addressed the issue with the employee informally and, you've yet to see improvement. Therefore, we would advise you to start invoking this process. So like any sort of formal meeting, you should be writing out to the employee, inviting them to the meeting. So best practice would indicate, you know, that employees should be provided with at least a minimum of 24 hours notice. It's really, really important that you do give them the sufficient notice of the meeting and you're not just springing it on them, you know, last minute. And it's another important element here when it comes to these formal meetings. It's really important to inform the employee that they are entitled to bring representation to the meeting. So the legislation does state, you know, that representation could be maybe a trade union rep or maybe a colleague, and any request to bring in someone outside of this remit requires your decision as the employer for approval. So I'll just give you an example on this. I've seen a situation before where an employee rang in to ask if they could bring a solicitor to the meeting, and because this request, you know, it was unreasonable, the employer was allowed to refuse in this case. And then obviously during the meeting, which is the purpose of the meeting, you should be making the employee aware of, you know, where they're falling down, what are the matters of concern. And when it comes to this, you can't be just giving generalized feedback to them. You need to be really, really specific with examples and make sure that you are giving them concrete examples. So what you would do then, you would inform the employee of when you expect to see improvement in regard to what the issues are. So the code of practice doesn't, you know, specify an exact timeline as to how long you should give them, but from my experience and recommendations, reading recommendations from judges, employers should be giving their employees 1 month to show improvement. But however, you know, employers could give less if it's a more serious case of insubordination or underperformance. So I think the most important thing is here, treat it as a case-by-case situation and make sure that you are always being fair to the employee. And then lastly, keep records and follow up. So document the minutes of the meeting, file them away and make sure that you have them in record, and follow up in writing with the employee summarising what was discussed during that meeting. So after this then, you know, or at this stage, you would consider if you need to extend the probation or not. So if you are going to extend it, make sure you refer back to your contract of employment, that there is the clause in there which will allow you to do so. And then, you know, make sure that you have a substantial and justifiable reason as to why the probation needs to be further extended. So next then we would move on to stage 2. So this is the at-risk stage here. So this stage would occur if the issues that you've highlighted to the employee have not improved by the agreed date. So again, follow the same process whereby you would be formally writing out to the employee, inviting them to the meeting, and make sure that you're giving them sufficient notice of when the meeting is scheduled for. Make sure that the employee is afforded the opportunity of having representation at the meeting. And then during the meeting, again, reiterating the matters of concern with the employee. So make sure you're really specific, you're giving examples, and as well, if you have dates of these issues, make sure you're giving them to the employee as well. So as the title there, you know, outlines, the key word at this meeting is at risk. So you need to ensure that you're crystal clear to the employee that they're at risk of not passing their probation if they haven't showed improvement by the agreed improvement date. So then following on from that, you would set a new timeline as to when, you know, you expect to see improvement. So after this meeting, you know, you would have two main options here. So if you haven't already done so, consider extending the probation and make sure that the clause is there that allows you to do so. Or your second option would be to issue a formal warning. So in the regard that, look, if you don't show improvement by X date, we're formally issuing your warning that your employment could be terminated. So they would be your two main options. So then on the final stage, so if the matters of concern or the issues that you've addressed to the employee have not improved, you know, by the agreed date, you would then be invoking this final stage. So follow the same process as you would have done previously, writing out to the employee, making sure that they are offered the right to representation. And it's important then, you know, at this stage, you are considering all of the evidence. And it's important as well that the communication has been a two-way process, and this goes for the other two stages as well. You need to make sure that you are allowing the employees to give their view, and you know, you are taking their feedback into account. It just can't be, you know, a one-way process from your side. So this stage, you know, really is essentially an investigation meeting. So what you would be doing is reviewing all the facts you've gathered to date, and after the meeting, you need to make a sound decision based in regards to what the outcome should be. So once you've decided what the outcome is going to be, arrange a follow-up meeting with the employee and make them aware of what the outcome is of this meeting. So your two options here would be, you know, issue a further warning to the employee, and if you haven't already done so, extend the probation. Or your second option would be to terminate the employee. And the most important thing is, you know, when you do terminate the employee, and I do say it to my members as well, it's really, really important to note that the employee absolutely has the right to appeal that termination decision. So it's really important that you do afford the employee the opportunity, you know, to make an appeal based on what the outcome was. So then on to the next slide, we're going to have we look at the probation checklist that I've drafted up. So these are a couple of wee questions, you know, that you could ask yourself to make sure that you are managing the probationary period effectively. So the types of questions you should be asking yourself are, you know, did the employee receive full and proper training? So make sure that it is consistent with other employees' training within a similar role. And an opportunity to improve. So if you have addressed any sort of issues with the employee, you know, did you give them an opportunity to improve, and were you realistic in regards to when you expected to see that improvement? And again, adequate communication and support. So we're really, you know, reiterating that communication piece. You know, was your communication and support adequate to the employee throughout that trial period? And were you having regular reviews and feedback? So, you know, did you have your formal reviews as they were scheduled? In between them formal reviews, were you catching up with the employee, having informal meetings? And were you consistent in regards to the feedback that you were giving to the employee in regards to their performance? And if there were any issues, was the employee made fully aware of what the issues were? So then on to then the last section of my presentation this morning. We're going to look at 3 recent case law pieces regarding probationary dismissal. So the first one is a wrongful dismissal claim. So in this piece of case law, we have an accounts receivable manager versus a shared services centre. So the claimant in this case commenced employment as an accounts manager on the 15th of March, and they had a probationary period of 3 months. And this former employee was actually dismissed 6 months later due to poor work performance. So during a meeting that was held 3 weeks after she completed her probation, she was told that her probation was being extended for a further 3 months. So this did come as a surprise to the former employee, as she wasn't aware of any issues with her employment and was never informed that she was at risk of not passing her probation. So she did claim, you know, that she had already become a permanent employee at the meeting, as this meeting was being facilitated after her probation had ended. So the managing director was the one who was facilitating these meetings, and he responded to her by telling her that 3 months probation was too short. And he also told the complainant during that meeting that she had undermined him at the start of her time with the company. And she said that she wasn't aware of this and wondered why it was only being addressed at month 4. So the claimant felt that she was treated differently by the managing director and had never been given credit for her work. So then a final probation review meeting was arranged for September, which was actually past the date of the further 3-month extension, and she only received notice the day prior and was advised to bring a colleague as a representative. So as soon as she received that invitation, she actually made a formal bullying complaint to HR regarding the managing director. So she told HR that the bullying had started after she had questioned her initial probationary extension. She said that she was ambushed at the final probation meeting and believes that she was dismissed not because of her work performance, but because she had actually raised a complaint of bullying. So to summarise then, the claimant raised a complaint to the WRC with a claim under the Minimum Notice and Terms of Employment Act. So she wasn't given the notice as outlined in her contract. And she also claimed that she was penalised under the Health, Safety and Welfare at Work Act for raising a complaint of bullying against her direct manager. And she was not afforded fair procedures as per the Code of Practice on Grievance and Disciplinary Procedures. So then on to the next slide for the outcome. So the adjudicator upheld the complaints, and they did note that, you know, the final probation review meeting did suddenly turn disciplinary, which was penalisation for the formal bullying claim that was raised by the former employee. And they also noted as well that the dismissal was sudden and preconceived insofar as the removal of the claimant from the premises, confirmation of pay in lieu of notice, and the return of her company phone flowed immediately after dismissal was announced. So the outcome of this was that the claimant was awarded €20,000 under the penalisation under the Safety, Health and Welfare at Work Act and €10,000 under the Minimum Notice and Terms of Employment Act. So, you know, awards, particularly of this size under the Safety, Health and Welfare at Work Act, are quite rare, and the decision, you know, may be seen as surprising by some. But the key point, you know, here is that it underlines again for employers that there are risks involved when you are dismissing employees during probation and employees that have less than 12 months service. So we move on then to the second piece of case law. So in this particular case, we're going to have a look at a claim taken under the Industrial Relations Act. So in this high-profile case of Park Hotel Kenmare versus a worker, the Labour Court found that the former general manager of the hotel had been unfairly dismissed while on probation. So the former employee claimed that he was dismissed without warning after being called to a meeting with the managing director, who informed him that it was not working out during the probation. So the claimant took a case under the Industrial Relations Act claiming that he was unfairly dismissed. So the hotel did argue that it was entitled to dismiss the employee during probation by the giving of notice, as this was outlined in the employee's contract of employment. But the Labour Court did respond by saying, look, we do accept that the employer absolutely has the right, you know, to decide not to retain an employee during the probation. However, it did state that this can only be carried out where the employer adheres strictly to fair procedures. So the court concluded that fair procedures were not applied in this case, as the employee was not provided with any details of performance issues. There was no warning given that his employment was in jeopardy. He was not afforded the right to representation. He was not provided, you know, with the reasons for his dismissal. And then lastly, he was not afforded any opportunity to respond or to reply to that decision that was made. So subsequently then it was recommended that he be paid a compensatory award of €90,000. So this case again underpins the importance for employers to have the regard for the rules of natural justice and in applying fair procedures to employees on their probation. So then the last piece of case law that we're going to have a look at is a claim taken under the Employment Equality Act. So to further look at this, sorry, my slides are a wee bit slow. Perfect, there we have it. So now we will have a look at this employment equality case law piece. So in this case, the complainant referred a claim to the WRC alleging that she was unfairly dismissed by her employer on the basis of her gender and her pregnancy. So the complainant's probation was extended on 2 occasions. So the legality of the first extension was queried by the adjudicator, as the company neither provided the complainant with an explanation for the reason behind that extension, and there was no meeting facilitated to explain the issues that led to the extension. So this, you know, straight away represented a breach of the principles of natural justice. And the second extension, according to the employer's account, resulted from the claimant's poor work performance, But contradictory to this, there was actually a letter issued to the claimant which stated that the extension was due to the employee being on sick leave. That letter made absolutely no reference to the probation being extended due to poor work performance, but rather it cited it was being extended due to sick leave, which actually related to the complainant's pregnancy. And prior to that second extension, the complainant had found out that she was pregnant while she was in hospital, and she did subsequently inform her employers and was off then for a period, she was off on sick leave for a period of 2 weeks. And then so that was in August, and then when she returned from her period of sick leave, the complainant then took 2 weeks of annual leave in September. And then when she came back from that annual leave, she was actually issued with a letter by her employer which listed out all of her shortcomings. And then shortly after this, in October, she was issued with a letter of dismissal with immediate effect, citing poor performance as the reason for dismissal. So the adjudicator did question, the authenticity of the claimant's probationary extension, and they also did question that list of the shortcomings. They said that that particular list did lack detail in relation to dates of the alleged poor performance, and that the shortcomings that were referred to in that list were of such general nature that the complainant couldn't even have the ability to respond to them. So the adjudicator commented that there was no evidence presented relating to any work performance issues during the complainant's employment, and therefore they found that the complainant was in fact dismissed on the basis of her pregnancy, and she was awarded a compensation amount of €40,000. So lastly then, just to summarise the presentation, and just that we'll go through some key takeaways which hopefully you will have taken away from today's presentation. So firstly, and most importantly, I think it is anyways, that you should have a probationary clause. So either in your contract of employment, or I've often seen it within a probationary policy that's maybe outlined in a company handbook, and make sure that you do have, all of them details that I outlined earlier on in the presentation within that clause. The next point is there are risks involved if you dismiss an employee during their probation with no notice. So I do hope, from us going through this presentation this morning, you are aware of what the employee has recourse to, and you are aware that there is fair process, that they are entitled to fair process. So there is absolutely, a risk involved there. So the next takeaway is employees on probation are entitled to the principles of natural justice and fair procedures. And, even though it's not, necessarily required to use your full disciplinary process for employees on probation, you must adhere, to fair procedures regardless. And then touching again on that communication piece with your employees. So you should be having regular communication with your employees, so both in an informal and formal manner. And then the next point is your paper trail. So again, the documentation piece. So make sure you are documenting all conversations and meetings with employees. And then lastly, there should be no surprises when it comes to probation. So if an employee is at risk of not passing their probation, then they should be fully aware that this is a possibility, and they should feel that they have received a fair process up until this decision is made. So that actually brings us to the end of my presentation today. Thank you very much for listening. And Emma, I might just, or Sven, sorry, even better. I'll hand back over to you, Sven.
I'm not going to talk to Emma what you meant by even better, but thank you so much. Thank you so much
you caught me by
your
surprise.
Thank you so much for your presentation. Yeah, I see we have a few minutes left for questions. So there was just one question coming in. You should be well able to answer this. When you record a conversation with a problem employee, do both parties have to sign the notes, or is it just important for the employer just to create it, put it on file, and doesn't need to be signed by the employee as well?
Well, I suppose if you're, I know in the current situation, the current or pandemic that we're in, a lot of these things are maybe happening, virtually. So say, for example, if you're meeting with an employee, virtually, and maybe you're doing it through MS Teams call, or maybe Zoom, or whatever platform that you're using, make sure that you do inform the employee, you know, that this recording is going to be recorded, and make sure that you do have their consent. But that particular recording would only be really used for the purpose of the meeting. But any of these meetings that you are having with the employee, I think it's important that you're following up in writing, that you're not just referring back to a recording, that you're following up in writing and taking minutes of what was discussed during that meeting, and you're making the employee fully aware of what the outcome was of the meeting, so that there's no, you know, there's no confusion there between both you and the employee.
Then a question in relation to, you know, the fact that small business owners or HR representatives in small businesses can be really busy, and for whatever reason, there's an employee on probation, but they didn't have the chance to hold a formal review before the probation ended. Does that mean that the employee in question has passed the probationary period?
That's a really good question, and that's quite a common question that we would get in, and I'd say Emma would also agree. So essentially, yes, it does, Sylvain. So the idea, you know, of having a probationary period and putting that clause on it is to let the employee know that it is a trial period for X amount of months. So whether you put in 6 months, they are aware that it is a trial period for that specific amount of time. And if you haven't communicated with the employee during that period regarding any sort of issues, you know, the employee is right to think, and it is only natural to think, well, look, there's no issues with me, as nothing has been communicated to me during this period of time. And when it comes to that probation ending, you know, they are right to believe that they have successfully passed the probation. And, you know, that really does reiterate that, you know, communication piece. And I know I've probably repeated myself a number of times throughout the presentation, but it is really important, you know, when you're scheduling those formal reviews, you know, that you are having them, and you are having that regular informal meeting with the employee. And if it comes to a situation where, you know, the employment is going to be terminated during probation, it should never come as a surprise, you know, to the employee. They should feel that they have received that fair process and understand why the employment is being terminated. And generally when that happens, you know, you are limiting exposure to yourself.
And Tammy, what happens, another question here, what happens if an employee due to COVID or otherwise has been temporarily laid off during their probationary period? Is this going to be added on, or what way does it work?
Yeah, so that's another great question, and I suppose in light of COVID-19, this was a common issue over the last number of months for a lot of service providers, maybe, and, you know, small business owners. And I suppose the answer to this question would broaden out to other absence scenarios, such as maybe sickness or maternity leave as well. So if this happened, you know, you should be informing the employee that the probation period will be paused. So letting them know that, you know, due to the fact of being on temporary layoff, their probation is going to be paused. And remind the employee that the purpose of the probation is to determine their suitability, as that was outlined in the probation clause. And once they come back to work, so once you reopen and the employee is back to work, that period of time will be unpaused in terms of their probation. And if, you know, if you're discussing this verbally, make sure that you formally put it in writing as well, to make sure the employee is fully aware. And I suppose, you know, it's important to bear in mind that, you know, you can really only extend that probationary period up until 11 months, because the Unfair Dismissals Act will then, you know, kick in there once the employee is 12 months or more service.
Tammy, last question. You had a lot of examples of underperforming employees, but what if you have a fantastic employee on probation? Is there a way, or would you recommend to shorten their probation period, or what way would you handle somebody who's overperforming?
Okay, well, firstly, that's great. You know, it's fantastic when you come across employees that they're absolutely fantastic and they're surpassing your expectations. And yeah, look, you absolutely can shorten it, you know, if you wish to do so. However, you know, I would be cautious and say to you that, look, when employees are aware that they're on probation and they're aware that they're being continuously assessed, it is only natural, you know, that you are the very best version of yourself. And they're probably really trying to make that good impression with their employer. So I wouldn't really recommend shortening it. You know, you should just follow through with the original agreed term that's within your probation clause, because again, you know, this could be seen as setting a precedent, but you should be, you know, following through with that agreed term. And look, absolutely let the employee know that they're performing really well and give that positive feedback to them during your reviews. However, I would be inclined to steer away from that, because be cautious as well of setting a precedent there.
Great, Fiona, thank you so much, and thank you for your time also in answering the questions. There's, in the interest of time, there's a few questions that we are going to answer offline. We get back to you if we haven't been able to answer your questions. So, Fiona, thank you so much.
Lovely, great,
I'd now like to introduce our final speaker. Well, Emma, you've been on and off a few times already today. So Emma, if you could turn on your camera, hoping that your broadband is holding up in the Republic of Cork. There you are.
It absolutely is. I'm just going to share my screen there now.
That's great. And just to say, in spite of the pandemic and all that's been happening, the legislature hasn't been sleeping. There's lots going on the HR and the employment law space, and you're going to, in your last presentation, just update us on the latest developments and things that employers need to look out for in the coming weeks and months.
Absolutely. Well, look, firstly, thanks for the introduction, Sven. And again, look, I've spoken to you a few times today, but look, again, good morning. I hope you're getting an awful lot of information from today's seminar. I'll try leave on my camera for the presentation, but look, my internet might drop at some point, so I hope someone will let me know. But look, I suppose I have been reflecting on some of these HR updates and changes in preparation for today, and we can all agree that the past 12, 13 months have been the most extraordinary months in our working careers. Well, I know it has been for mine anyway. And what comes with that is even the scale in which the employment legislation and the regulations that are being proposed for this year is a significant focus. It will of course then impact how we manage our workforce and how we work in the future. So I hope this presentation now today on the HR developments and topics like the right to disconnect and the right to request remote working will provide you with the knowledge and the resources to ensure that your business is well prepared before they come into place, and just down the line, in terms of practice, best practice, bringing in policies. So on that note, I'll move along and introduce you to the topics that I'll be discussing. So today's agenda, as you can see, is we're going to be looking at the recently published Workplace Bullying Code of Practice. So that has come with some changes, and employers absolutely need to be aware of them. We'll be looking at the Code of Practice on the right to disconnect and the soon to be legislated for the right to request remote working. And there are proposals then coming down the line with the statutory sick pay, which is expected to come in by the end of the year. So we're going to look into that. And then we're going to look at the whistleblowing directive, which is coming down the road for employers. It's due to form part of legislation by the end of the year. It's December this year. And then finally, we're going to look at the family leave developments. So all of these changes are either here already or they're coming down the tracks. And as a result, employers will have to be aware of them. And I suppose then from a practical level, they need to be aware of what policies they need to change, amend, or even introduce, just to be in line with the legislation. So let's get started then. So we're going to start off with the Bullying Code of Practice. Okay, so the government have released a unified bullying code of practice. It's 54 pages long, and this code of practice, it was actually published on the start of January. I think it was the 5th of January this year, and it was developed jointly by the HSA and the WRC. So that code of practice replaces and updates the separate codes that existed before now, and they were published by each of those organisations. So they came together to develop this code. I suppose employers really need to be aware of that a code of practice, while it's in place, if you fail to observe or comply with that code, in itself it's not an offence, but the code does explicitly state that it can be used in evidence before the WRC and the Labour Court, just to show whether the employer has complied or not complied with that code. So it's really important for HR professionals or business owners today on the seminar just to understand the rules and the provisions that are set out in this code. It deals with bullying at work, so it does highlight that. And just for your own information, look, harassment is a very different concept. So the code of practice, it provides a list of examples, and they're non-exhaustive, of what is and what is not bullying. So something that it discusses or it describes to be not bullying would be performance management and constructive criticism. So maybe some feedback you give back to your employees. Now, this development is particularly positive for employers because in the past, you know, sometimes employees can just call something out as being bullying when it's not. Now, it also looks at the risk of cyberbullying for the very first time. So it does acknowledge that, you know, bullying can take place anywhere. It doesn't matter if the employees are working remotely, if they're in the office, if they're in a hub. It specifies that, look, it needs to be addressed, and you can address that either through a policy or at some training. Now, another interesting thing with this code is that it states that bullying can be conducted by those not employed in the business. So that could be, let's say, your customers, your clients, your business contacts, anyone who comes into the workplace area or who deals with your employees. So any anti-bullying policy that you do decide to either update or implement, it should be displayed in a place where these sort of people might attend. Now, I suppose lastly, there is a huge focus on resolving bullying at the earliest stage. So one change of this code of practice is that it looks at the topic around mediation, or it could be known as the two-stage informal process. So before, there used to only be one informal stage, and there was a formal stage. So it underlines the employer's responsibility to clearly state that bullying in the workplace is not acceptable, it's not going to be tolerated. And then you're going to deal with any complaints, you know, sensitively and privately. So again, this is a positive development. It's an opportunity for you, all your, I suppose, the employers and the employees, to create a framework to, I suppose, and a plan to discourage these behaviours and obviously resolve them if and when they do arise. So bullying, look, it's been a long identified problem in the country, and a costly one for that as well for businesses. And back in May last year, the Irish Times reported how every year a total of 1.7 million days are lost due to the workplace bullying, and that is a cost of 239 million. So according to this research published, there are two key points highlighted. So first, they had acknowledged that by simply having an anti-bullying policy in place, it's not enough in itself. It needs to be implemented fairly and in a timely fashion. Secondly, employers need to be proactive and develop specific interventions. And I suppose both of those ideas have been carried forward into the code. Okay, so the issue of bullying and harassment can cause serious concern for employers. So it's really important to either have a dignity at work or a bullying and harassment policy. Obviously, this look will just, I suppose, acknowledge the employees that you're trying your best to, you know, it's going to show your commitment to try to create a safe and healthy working environment, which is free from all of these issues outlined. So this code of practice defines that workplace bullying is repeated inappropriate behaviour, direct or indirect, whether verbal, physical or otherwise, conducted by one or more persons against another or others at a place of work and or in the course of employment, which could reasonably be regarded as undermining the individual's right of dignity at work. So, in essence, a once-off incident is not considered to be bullying. Now, there's a case that comes to mind when we look at bullying and we look at the definition of bullying, and it's the Ruffley versus Board of Management of St. Anne's School 2017, and I have discussed this in previous webinars. I suppose the reason why it comes to mind is that at the time of this case, the Supreme Court had acknowledged that they knew that that case would set a benchmark for all future bullying claims, because I suppose their decision is very much reiterated in this code of practice. Like, bullying up to now has been a really easy allegation to just throw around. But looking at this definition, bullying is essentially meeting 3 minimum criteria. So it has to be inappropriate, it has to be repeated, but it also has to be reasonably regarded as undermining the employee's right to dignity at work. So it's not enough just to say it's inappropriate and repeated, it must also be undermining their dignity. And that was very much the case in that Ruffle hearing, that the alleged behaviour had to meet the certain minimum threshold to actually constitute bullying. Apologies, we'll go back one. Okay, so looking at this, look, I suppose you're all well aware that employers, they understand that it's your responsibility to provide a workplace free from bullying and harassment. It's outlined in the Safety, Health and Welfare at Work Act. As a result, then it's imperative that you develop and distribute a policy. Now, this policy has to be up to date and it has to come with a procedure. So the main focus of the code really is the resolution. And that resolution is going to be a 3-stage process. Again, I've already said that, look, before it was an informal and a formal process. Now it has 3 steps. So there is an informal initial process, a secondary informal process, and then the 3rd step, a formal process. So this slide just outlines the steps that I suppose we're recommending you take when you're preparing a policy. So the objectives of policy should be to increase awareness of bullying and harassment. And this can be done by updating the bullying and harassment policy or the dignity at work policy, and then educating your employees on the issue. So we'd recommend that businesses conduct some sort of, I suppose, whether it's an annual training or it could be an awareness campaign, and that should be done annually as well, just around what constitutes bullying, and then I suppose the employer and employee, their obligations, just to create, again, awareness around that. The second thing is encourage good communication. This is so that concerns can be raised without fear. Okay, that's the goal. So in general, employers should be having conversations with the employees about their well-being. And I know, being a small business, it can be really difficult, it can be really timely, but it's really important that as a business owner, you do have a good relationship with your employees to understand their work environment, any difficulties they might have, whether it be with maybe another employee or another manager. And Section 8 of the Safety, Health and Welfare at Work Act states that an employer's duty extends to the following. So that's managing and conducting work activities in such a way so far as is reasonably practical, any proper conduct or behaviour likely to put the safety, health or welfare at work of his or her employees at risk. Also, set standards for acceptable behaviour. So this should be displayed throughout the company's bullying and harassment and or dignity at work policy. And this also relates to how issues of conflict, bullying and harassment are resolved. So again, there should be both an informal or 2 informal steps and a formal method then of resolution. Just looking there as well, you need to outline everyone's individual responsibility to inform themselves of the policy and their responsibility to resolve matters if and when they do arise, and that should be dealt with as quickly and as confidentially as possible. And then finally as well, just to promote an environment in which diversity is respected. Okay, so a takeaway from this would be to use this as an opportunity to train or retrain your employees on workplace bullying, what to look out for and how to stop it. So we would advise businesses to amend and update their policies, including those changes already mentioned. Now, while the SFA can provide business owners with sample policies, I've already mentioned earlier in the day that we do have all these sample documents for you, including the bullying and harassment policy, which has been updated, and the dignity at work. But it's really, really important that, if you're using those templates, you have to amend those documents to suit your own business environment. So you should be beginning the document, let's say, with a clear and strong statement of commitment from you. It's really imperative at the beginning of the policy, there's a statement that bullying and harassment is not tolerated, zero tolerance. The policy should then outline examples of unacceptable behaviour and examples of what is not deemed to be bullying. It should outline the responsibilities of all employees in the promotion of a bully-free workplace, whether it's during the working day or it could be at working events. It could be on site or it could be off site. So basically it's anything that's work related. And another note then would be that this code of practice only deals with bullying. So I've mentioned that harassment is a separate concept. Harassment is actually dealt with in the employment equality legislation. But what's really interesting is that for any of you today here listening to this presentation, if you need to update your policies, it is okay to have those two issues together, as long as you include the changes that I've emphasised, especially the one that there's a bigger, you need to really highlight that there needs to be, I suppose, a bigger focus on the informal resolution first. There's two informal stages. Okay, so the right to disconnect. So it was actually April this year, the 1st of April, the WRC implemented this right to disconnect code of practice. It basically sets out best practice for employers and employees. Okay, so when you think about the right to disconnect, we all know what the title means, but when you think about it, in the past 12 months, employees have acknowledged that they're always on. They can never switch off from work because they've access to their emails and documents on their tablet, their phone, their laptop. It could literally be pinging on the dinner table and they either feel obliged to read it or sometimes reply. Now, other EU countries have already begun to legislate on this area, but Ireland is not going to legislate for it, which is a brilliant thing, okay? So again, they're going to be bringing out this code of practice, and a breach of the code is not an offence, but at the same time, it is admissible for best practice in proceedings before the WRC and the Labour Court. So when they were bringing out this code, they needed to be very careful not to introduce any unnecessary rigidity into, I suppose, what's essentially an increasing flexible workplace. So it's great that there's no barriers to this flexibility, because of course it's important to disconnect, but there has to be an awareness that we are becoming more flexible in our workplaces. You know, I suppose this code of practice focuses on supporting the employee's right to disconnect rather than just restricting it. And recognising that sometimes an employer will have legitimate reasons to contact an employee outside of those normal working hours. So in terms of the code, it confirms that the right to disconnect has three main elements. The right to not routinely perform work outside of normal working hours, the right to not be penalised for refusing to attend work matters outside of normal working hours, and the duty to respect another person's right to disconnect. So the code really focuses on those three areas, and it also sets out employers' and employees' obligations, which we'll now look at. So the code makes reference to other employment legislation. So employers are obliged to give details around working time under the Terms of Employment Information Act 1994 to 2004. There is the Employment Miscellaneous Provisions Act, which came in 3 years ago. This obliges employers to give a certain amount of detail to their employees around normal working hours, what they're going to be reasonably expected to do, and that was to be given to them no longer than 5 days after the date of commencement of employment. So these hours, as I said, are what they are reasonably expected to work in a normal day and a normal working week. Now, we all know by now that employers are obliged under Section 25 of the Organisation and Working Time Act to record working time. So that includes their start time, their finish time, their breaks, their daily and weekly hours, and also their annual leave taken. So employers have to monitor this, and they have to retain the information then to comply with this piece of legislation. And of course, it is a health and safety piece, okay? So working time does fall under the radar of health and safety. It's really important that, I suppose, employers understand that their obligation is to ensure that they, I suppose, facilitate employees being able to disconnect from work and the work devices. So look, we have seen with this topic, we're all aware that liability falls on the employer for failure to record working hours and ensure compliance with the working time. But let's say, you know, an employee is working outside of the normal working hours and they're working at home, and an employer is unaware of this, the liability still falls on an employer. So that there's a big consideration there. So we're just going to look about that in more detail. So Even though liability rests with the employer, there are obligations on the employees. So it's vital that employees fully cooperate with any mechanism used by the employer to record the working time. So they have to comply with that. They have to reasonably care for, I suppose, themselves. They have to protect their safety, health and welfare, and that of the co-workers. And that includes disconnecting. So employee does have an obligation to do that and to respect the rights of the colleagues by not routinely making work-related contact outside of those normal working hours. Okay, so that's the important word. It's how often. Is it a routine? Is it occasional? Take responsibility. I suppose they need to be mindful of their own work-related well-being and ensuring that they do disconnect and they do take their statutory rest breaks. So there is an obligation in both parties, as you can see there. There's obligations for the employers and obligations for the employees, and that's really important in terms of best practice, that they both need to be, I suppose, communicated and they both need to be implemented. So the code, it does recognise that each business and its workforce will have its own particular needs. It recognises flexibility, which is fantastic. And it recognises that employers will need to make contact with employees outside of normal working hours. And I suppose the code looks at that. It looks at the frequency of the contact. So look, it's not saying that you can never contact employees outside of normal working hours, but it's how often you do so. And I suppose you must have, legitimate reasons. That's really important. So how often and what legitimate reasons do you have? So again, it focuses on that support element. Can you support your employees' right to disconnect rather than restricting it? And that's really important in that piece in the code of practice. So only when it becomes regular or when it's done without legitimate reasons will it become a concern. So we'll move on to remote working. Okay, so the concept of hubs and remote working has been growing over the past number of years. It was on the government's agenda pre-COVID, but look, of course, over the past 12, 13, 14 months, there's been a rapid increase in the take-up of remote working. And it has become more obvious the past few months that there's been a clear need for guidance for employers on remote working. And it's crucial now more than ever because look, COVID has accelerated this whole process. So on the 15th of January this year, the government published the National Remote Working Strategy, and that set out essentially the roadmap and even the ambitions, the plan for the future around the remote working and the legislation. So this is the plan, and the legislation is going to be coming down the line, but we don't know what the legislation is going to look like. There's no legal framework, but we do know that, look, it does intend to provide some clarity to employers around the best practice, especially in how you deal with those requests. So the government intends to legislate to allow employees the right to request to remote work. Now, this legislation is due to come out at the end of the summer, I think in the third quarter of this year. And just understand, this is just the right to request remote work. Not automatically the right to get it, and it's not just a COVID solution. So looking down the line, it will impact the future of our work and how how roles are going to be adapted. And employers need guidance because you have to remember, an employer has the obligation to reasonably care for the safety, health and welfare of their employees, and that's whether they're in an office, on site, in a hub, or in their employee's home. And of course, there are benefits to small firms in terms of this remote work piece, and it could be, it could be diversity, it's talent retention, it's just being a more flexible working place. But there are challenges, and one of these challenges, look, no doubt, we're all well aware, it's going to be cost, it's going to be insurance. So the cost is not limited to providing the equipment and the resources, but it is insurance, and it's going to be the compliance to data protection and security in a remote working setting. And in December last year, so was it 2020, the Department of Business, Enterprise and Innovation carried out a public consultation. And now the SFA did make a submission making recommendations. Some of you might be aware, you might have given in your feedback. So the SFA submitted that in considering remote working as a longer term solution, further incentives, including, let's say, tax relief incentives, absolutely are required to offset those challenges and cost impact rising from this arrangement. So how an employer best adheres to employment law and their obligations within the employee's place of work, be it their home or in the office, that's something that employers need guidance on. So to give you an overview, I'm going to go just through some of the employment law considerations. So including how you record your working time within what's essentially the employee's home. And as mentioned already, on the right to disconnect. So employers are obliged to record the working time, monitor them, and then retain that information. But now when an employee works remotely, it's the responsibility of the employer to essentially replicate or devise some sort of time management system. So working from home poses challenges because you're going to have to monitor the working time, comply with the Organisation Working Time Act, as well as complying with the Code of Practice and the right to disconnect to monitor the time spent disconnecting from work. And that's not something that's just easily done. So as I mentioned, our submission, which was submitted last year, that raised, I suppose we raised this concern. We highlighted that employers do need more guidance. And it shouldn't be a case of, from employers trying to comply with this, piece of the Organisation Working Time Act, that they breach other legislations, and that could be the data protection legislation, or they could be in breach of the Article 8 of the right to privacy. So look, again, the right to disconnect, how you're going to ensure that they're disconnecting while they're at home. It's a huge consideration. Another issue is the one around equality. So look, we don't know what the legislation is going to look like, but we do know so far that there will be the right to request it, and an employer will need to give grounds for the refusal. So, there should be objective grounds. There should not be ones that could give rise to equality concerns. I know Lorraine spoke about this earlier, but I suppose essentially, look, if an employee wishes to work remotely, it's their responsibility to just find a workspace within their home. But you have to consider that for an employee who lives in a shared space, a shared home, there could be data protection risks, especially if they're working with confidential, or even personal data. And we have to note that generally it is the younger population that would be sharing a home with other tenants. So if an employer refuses the employee the right to request, I suppose the right to work remotely on the grounds of potential data breach, could that be an age discrimination claim for that particular employee? Another example would be that if the company couldn't afford to resource or replicate that workspace. So if an employee had a bad back and they were given an ergonomic chair for the office, if they couldn't afford to replicate this workspace, and they then as a result had to refuse their right to request remote work because of this cost, could that give rise to an employment equality claim based on the ground of disability? So look, as I'm speaking about cost, this is another consideration. So no doubt it's a big concern for small firms. If an employee wants to work from home, it's essentially the employer's responsibility to ensure they can replicate an office environment for the employee in their home. That could be a work desk, it could be a laptop, it could be any sort of other equipment, or even I said there, an ergonomics chair. So essentially you have to equip 2 workspaces. There are also data protection concerns. So when an employee is working from home and they're working with personal data or just, I suppose, confidential data, it could be about clients or customers, the employer remains the data controller, and then they themselves are still liable for any breach of data protection by the employee, even if the breach occurs in the employee's own home. So look, again, what you need to take from this is, look, no doubt you need guidance, and we've highlighted that in our submission. It's out of your control right now. While they're working from home, it's really hard for you to manage that. But yet the statutory requirements remain the same. That hasn't changed. So there are issues that we need to look at. Employers need to be very clear on how this down the line, how they're going to best manage it, and how they're going to manage the requests, how they're going to manage the remote working, and then again how they're just going to adhere to the employment rights in a remote working context. So employers who currently have a remote working policy, you'll have to modify it, update it, amend it, and communicate it to all your employees, and make sure it's in line with this legislation when it does come out. It is one to watch. There will be huge changes from an organisational and an employee perspective. I just thought I'd just bring this into it, I suppose, because again, I've mentioned this EU directive on the work-life balance. I've mentioned it a few times in previous webinars. It's basically a directive given to EU states which allows for flexible working. So it obliges EU member states to develop legislation themselves on the right to request flexible working. Now, flexible working is a much broader term compared to remote work. It includes things like part-time working, job sharing, shift patterns, and this directive then provides employers that you either have to decide whether you're going to accept or refuse that worker's request. So it's just important to note that. Okay, so while the remote working legislation will be introduced later this year, this flexible working legislation is due to be implemented next year. I think it's August 2022. So we'll update you on all the remote working legislation as it's released. And again, it's just one to watch. Okay, so just moving on to more legislation. This is coming down the line. So the statutory sick pay proposal. Okay, so the government is intending to legislate for sick pay. Now, we all know that there is currently no legal requirement by an employer to pay an employee for sick leave unless it's specified in the employment contract which you both agreed to. But the Labour Court introduced a bill which is currently at the second stage of the Dáil, and it will be passed at the end of the year. So in September last year, the Labour Party proposed to obligate employers to pay 6 weeks of sick leave after just 4 weeks of being absent, or sorry, 4 weeks of employment. So the bill has been delayed to give the government an opportunity to bring forward more proposals on the statutory sick pay, because I suppose the SFA made a submission to the Department of Enterprise, Trade and Employment of public consultation in December, highlighting the challenges facing small businesses already, and that this is an additional cost and it would be a huge burden for you. So the SFA believed this proposal, I suppose the proposed introduction to statutory sick pay in the current economic climate would be financially irresponsible and unsustainable. It'll come as a cost to a business at a time when you're under huge pressure. And if employers were to comply with this, no doubt it would have adverse effect leading to other cost-cutting measures. And the SFA submitted that small firms of less than 50 employees should be exempt, or at least there should be proposed alternatives or financial supports. So while this has come up over the past few years as a possibility, obviously the onset of COVID brought this issue to light, and we don't know what yet the legislation will look like, but we do know that it would be sustainable and affordable. As the Taoiseach had stated, that it needs to be fair and affordable for employees, many of whom have faced great difficulties this year. So in our submission, which I've mentioned, the SFA answered a number of questions based on the feedback from our members. So the key areas we discussed in the submission is that we want to see a fixed percentage of an employee's weekly earnings with a cap. Now, this cap could be similar to the cap that's placed in statutory redundancy. In terms of the duration of payment, we submitted that under any statutory sick pay scheme, employees would be covered for at least 15 days, and that would be by the employer, and then it will be followed by social welfare, and that we believe that would be reasonable, because anything beyond that, you know, look, it would have to be introduced incrementally over a number of years just to make it affordable for small firms. In terms of waiting days, in light of this illness benefit changing from 6 days to 3 days, we have acknowledged that it would be reasonable and that an employee could receive sick pay upon the fourth consecutive day of absence. And we've also acknowledged as well that the length of service, okay, so there should be a requirement, and this goes along, this was all in your feedback, okay, so we do believe that there should be a minimum of 6 months service. Anyone who's going to receive this, they should have at least completed their probation period as outlined in their employment contract. And we've also looked at employer supports that will help them in this additional cost. Now, we've yet to see any proposals, but it's just to let you know, employers know that it's something that we are actively engaging in. So the whistleblowing directive. Okay, so we know that this is coming down the road for Irish employers. You might be aware of the Protected Disclosures Act, which came back in legislation in 2014. That's going to be updated by December. And that's due to this whistleblowing directive and the EU directive. So there will be some notable changes. Already in the Protected Disclosures Act, that sets out, you know, grounds of what are relevant wrongdoings. So a protected disclosure is essentially where an employee discloses relevant information in which, in their reasonable belief, is a wrongdoing within the company. So a relevant wrongdoing might be committing an offence. It could be money laundering. There's a few issues there. So some of those breaches, and there's also, I suppose, corporate tax legislation as well. They're all discussed in this directive. So this 2014 Act, which is currently in place, it protects workers, but this new directive goes beyond that remit. It goes beyond the remit of employees. So now it's going to include people like trainees, volunteers, even applicants of a recruitment process, and, you know, interns. So they'll all be included in that protection. So again, it's just basically an expansion of the already existing legislation. Now, another notable expansion, or I suppose development, is the penalisation of whistleblowing. So this directive gives further examples of what constitutes penalisation. It's basically where I, as an employee, disclose a relevant wrongdoing, and as a result of that disclosure, I'm then penalised. So I could be demoted, I could have been selected for redundancy, or I received a disciplinary sanction. I'm basically penalised, or I received, I suppose, unfavourable treatment for disclosing that wrongdoing. Now, something to note as well is that it's the employee, they have the burden of proof, so they need to show that there was a link between the two. So an employee has to show that, you know, they were penalised for having disclosed that relevant information that they deemed to be a wrongdoing. So that piece is very important. But equally, the employer, just on that, I suppose, the employer is responsible then to distance themselves from that disclosure. So, for example, they have to prove that they fairly selected the employee for redundancy based on a fair selection matrix or method, and not because they disclosed the relevant information. So they do have to show that the two issues, they're unconnected. Another important piece to this is that it does require companies with 50 employees or more to implement an internal reporting line. This could involve a secure internal reporting email or system. Now, look, just to mention, even though it does specify that, look, companies, you know, with over 50 employees need to do this, you do have to understand that any employees, and I suppose today, the small firms with less than 50 employees, while it states that they're exempt from this rule in the directive, they're not exempt from all the rules. So we'll still be keeping an eye on this. We'll still be recommending that small firms consider implementing a whistleblower scheme, which would include an internal reporting line, as I mentioned. So what you could do is you could ensure compliance with this directive by just communicating to your employees that they can report a relevant wrongdoing to a particular person, and this is how you go about doing it. So it's, for obvious reasons, it would be a good idea just to implement this, just in case you look, you know, I'm dealing with small businesses of companies with less than 50 employees. You know, one of you today could have a company of 49 employees, and next year you could have 50 employees. So just to ensure that you know that you're in compliance with that at that time. And what it'll also do is it'll also send out the message, or even the signal to employees that the company wants to deal with the criminal or unethical behaviour. And then obviously employees should not be worried about reporting those wrongdoings. Okay, so we're going to look at family leave. So this Family Leave and Miscellaneous Provisions Act 2021, and again, I think Lorraine mentioned it earlier today on her presentation. So this piece of legislation amends the following acts. So it amends the Parents' Leave and Benefit Act, the Adoptive Leave Act, and the Paternity Leave and Benefit Act. Okay, so the Parents' Leave and Benefit Act 2019. So we all know that this act commenced on the 1st of November 2019, giving a statutory entitlement of 2 weeks state paid leave to enable parents to care or even to assist of the care for the child. So this leave, which it didn't have any service, it doesn't have any service requirement for children born or adopted from the 1st of November 2019. And then parents had 12 months to avail of it. So let's say that the first 12 months of the child's life, or in the case of adoption, it would be in the placement of the child. So now this Family Leave and Miscellaneous Provisions Act 2021, which commenced on the 1st of April this year, this has increased the entitlement from 2 weeks to 5 weeks. It also extended the time it could be taken from 12 months now to 24 months or 2 years. So these changes are backdated to the 1st of November 2019. So it's really important to understand that. So any parent who might have taken, let's say, their 2 weeks leave entitlement, they can now avail of the additional 3 weeks. So just consider that and just to maybe prepare, because I suppose we do expect that you'll be receiving more requests from parents just seeking time off for the childcare commitments. And just to note as well that this leave is likely to further increase over the next number of years, because the original 2019 Act allows for up to 9 weeks leave. Now, looking at the amendments to the Adoptive Leave Acts 1995 and 2005. So the Family Leave and Miscellaneous Provisions Act 2021 amends this Adoptive Leave Act. So it enables adopting couples to choose which parent may avail of the adoptive leave. And this is because the original act had an anomaly that left married male same-sex couples unable to avail of the adoptive leave. So now this new family leave, it removes that presumption that the adoptive mother is the primary caregiver. So this act permits adopting families just to choose the best option for their family. And now the only difference to the Paternity Leave and Benefit Act is one that relates to the amendments regarding the adoption. So the 2 weeks paternity leave, which will be available to the parent who is not availing of the adoptive leave, for example, in a couple situation, they can nominate who is the qualifying adopter, and then who is the other person in the couple. The other person then will be able to be, they can claim the paternity leave. So that's a welcomed development. So look, this brings me to the end of my presentation. Thank you very much for listening to the webinar. Look, I do really hope you found the content useful. The slides and everything will be available just to kind of refer back to. And look, I'll try answer as many questions as I can. And look, if I don't answer yours in the webinar, I will make contact with you afterwards to discuss.
Thanks so much, Emma. Really, a quick tour through all the changes. Some of them we know what's happening, others where we will need to update you on what legislation is going to look like. Then just a couple of questions, Emma, in relation to the right to disconnect. And I've seen lots of emails with a footer saying, I'm sending this email at a time convenient. To me, I don't expect you to answer this email outside of your normal working hours. In what extent does the right to disconnect obligate employers not to contact employees outside of working hours?
Yeah, okay. Well, I'm glad this question came in. And I'll just speak about this in more detail. So I suppose, look, yeah, I suppose in terms of normal working hours, look, they're set out in the employment contract as agreed by the employer, but understandably, the remote working, I suppose, arrangement that's been in place in the past year and the flexible working arrangements that have, they might have changed those normal working hours. So just important to know that. And then in terms of the contacting, this is not a blockage to communication. Okay, so that's one of the things that we're all really pleased about. We're welcoming this. I suppose it's not saying that you can't contact your employees outside of normal working hours, but it's looking at how frequently or how often you do make contact and how you as an employer support the right to disconnect. So the code focuses on, I suppose, this. There are of course occasions where you might need to make contact with an employee. It could be, And let's say for the childcare setting, it could be a particular evening where someone rings in sick and the employer then has to ring another employee to cover that absence. It's occasional, okay? So it shouldn't happen all the time. It's if and when it becomes regular, that's where it becomes a concern. So that's the key. There have to be legitimate reasons and it has to be occasional. And I suppose from a practical level, just a piece of advice, look, you should be having conversations with your staff about reasonable access. So I heard from one company, all right, that they're even having conversations with their employees, and they're agreeing with each other not to message each other out of hours, except in an emergency, which is a good start. And another idea I've come across is, telling the employees, please leave your work mobile phones at home while you're on holiday, or while you're, in the evening. Leave it in a certain place in the desk. Don't be taking it outside that room. And just to say as well, it's really important that employers communicate to the employees on the issue ahead of this. So look, we're currently working and we're developing a sample policy for this. I think we should have that in the next week or so. So it's really important to have a policy in place that should outline both the employers and the employees' obligations, but just really important that if we do, let's say, develop a template, that you do make it your own, put in your employers and your company's commitment to that.
Just a final question, Emma, conscious of time. In relation to the remote working legislation, are there any practical steps that employers can take now ahead of the legislation coming into force?
Yeah, okay, so I suppose from a practical level, what we would advise firstly is look at your company, look what works best for you, your company, and even just the roles that you have in your company. So for obvious reasons, you can't approve an employee's right to request to remote work if the role involves, let's say, carrying a load in from a delivery, or dealing with customers, or manufacturing a product. You have to be there in the workplace. So certain occupations just don't allow for it. But you should be thinking about where there is potential. If not for a full remote working, maybe a blend of the two. So it's really important from a business perspective is that you don't create an issue in your company where you create a two-tier system where there could be a breakdown of communication. That could be, let's say, because you have some employees on site and they're chatting to managers, they're hearing, they're face to face, they're hearing what's the issues with health and safety, what issues they're coming against. They're in the mix of it all. And then you have other employees working from home, and it's like out of sight, out of mind. So that's just one concern that we'd just ask you to kind of think about your communication and how you go about that. And another thing then as well is just businesses, you can start to develop a remote working policy. So in the SFA, we have plenty of resources. If you don't already have one, just be sure to contact me, and we have plenty of kind of clauses that you can implement.
Great, Emma. Thank you so much. Thank you for your presentation and also for your time. Before I let you all go, I just want to highlight that the 30th of April, so tomorrow week, is National Workplace Wellbeing Day, and the SFA is going to have a whole host of suggestions, activities, tips, information, and much more on our website, including a webinar on the day. So what we encourage you to do is really, not only on this day, but get some inspiration in relation to social, physical, emotional and financial well-being for your employees, and send out a message to them that their well-being is paramount. And the best way to do is, as I said, is go to the SFA website, see what resources we have there, and on the day, make sure that you engage on social media, Twitter, Instagram, LinkedIn, and share what you're doing for your employees online, and do this by tagging the SFA and using the hashtag WorkWell21. On that positive note, I'd like to thank all the speakers for their contributions today. I'd like to thank you, our participants, for tuning in today. And as I said at the introduction, you'll be receiving the slides of today as well as the recording in due course. And for more events and briefings, please go to the SFA website, sfa.ie. And should you have any questions, please don't hesitate in contacting us. The best email address is either sven@sfa.ie or info@sfa. So have a great day. Thanks a million, and God bless. Take care.